Yes, yes.
May I have your lordship's kind leave, my lord, to file an urgent petition with seeking your lordship's leave, my lord. This is in connection with encroaching of a public thoroughfare, my lord, unauthorized construction. This is some urgency in the matter, my lord. We'll serve, my lord. In the meantime, my lord, if your lordship grants us leave, my lord, let it appear on Wednesday, my lord.
What is the urgency?
They are encroaching a public thoroughfare, my lord. Around 14 meters of public thoroughfare has been taken over. Municipality has not given, the corporation has not given any sanction that this is in Asansol, my lord. There's some urgency, my lord. Grateful, my lord.
Madam, may I have your lordship's leave?
Let it appear on Wednesday, my lord, fairly at the top.
I am seeking,
Wednesday.
Madam, may I have your lordship's leave to, I am seeking leave, my lord, under the very compelling circumstance I am mentioning this matter. This matter may be taken up this side of this vacation, considering the fact that over my land, I have, my lord, fenced the wire by the barbed wire. The municipal authority, without mentioning any plot number, nothing of this sort, my lord, I have issued the stop order on 24th. Now, my lord, we approach them that it is my land, my lord, without, my lord, taking, my lord, the recourse of law, without mentioning in the notice, plot number, nothing of this sort, and
This will
taking the
come
advantage.
After vacation.
Your lordship, kindly see.
Your lordship's leave
Yes, Mr. Bhatt.
to obtain tender number. Or, Milord, so that it
What
is,
is the matter?
Milord, it's concerning, Milord, Asansol municipality's endeavor, Milord, at the instance of the landlord to evict me in a surreptitious way by suggesting that the construction which was constructed 70 years back, we are in occupation, Milord, my forefathers were also there. Now, Milord, they are saying that this is an illegal construction, Milord, without any plan, Milord. First of all, Milord, this construction has not come up at our instance. It has come up, Milord, it is long time, it's a long-standing construction, Milord. Now, what they are trying to do is, my godown is there. It's a, Milord, it's a business premises, Milord, which I use. Now, Milord, in a garb of this proceeding, Milord, they are seeking to demolish through the municipality, Milord, the land.
They have passed a 412.
Yes, yes. This is not, Milord, this is West Bengal Municipal Corporation Act.
All right, so they have passed an order declaring.
They have passed an order, Milord, directing self-demolition within 15 days. From the date of the order, Milord, that order is 9th of September without disclosing any report, without
But
resorting.
why will they give you any notice? It's either the
Milord,
owner occupied.
I am in occupation. The building is, whatever is being, is there, Milord, is occupied by me.
That is your civil right, Mr. Bhattacharya.
Yeah, 100%, Milord, the civil proceedings are pending.
Civil
Eviction
proceedings.
proceedings. Now, Milord, in the garb of this, Milord,
You have
yes.
a status quo order there.
No. In the civil proceeding, Milord, yes. Regarding, Milord, I have to make instructions. 100%, Milord, this, in the garb of this proceeding, in a surreptitious way, they are seeking to, Milord, evict me. Apart from that, Milord, this proceeding is without, Milord, the plan and
Your lordship.
may it appear on any
With
day.
your lordship,
Have your
may I
lordship's
permit
kind
your-
leave, Milord. Milord, very
What is
Milord,
Milord, urgent matter. Milord, I am
Wednesday?
Wednesday.
praying for this matter to be taken up on this side of the vacation, Milord.
Tell me.
Milord, a construction going on for 2 years. Milord, all the records of the corporation suggest it's
Your
land.
lordship,
They have
your
stopped
lordship,
it.
may I permit
Wait
you?
a minute.
Milord,
Wednesday.
Petition, my lord.
excuse me, Milord.
Has been converted into a commercial property and Starbucks is going to start functioning from tomorrow. It's a
What-
residential property. I am a co-owner.
Yes.
There is no consent of mine.
Yes.
My lord, the property has been converted into the ground floor has been converted into a commercial space. And from tomorrow onwards, the Starbucks is going to come. I'm challenging that.
Your lordship, may I, your lordship.
Milord, I am,
They're going to start open.
Tomorrow.
Milord, I am the
Just a
petition
minute,
of the
Just
26th.
a minute, madam. I'll hear you. I'm not going anywhere.
Milord,
Yes.
may I have your lordship's kind leave, Milord, for extension of interim order, Milord.
Give your slip. Wait a minute. Just let me hear these things. Give your slip. Yes.
Milord, extension of interim order.
Just a minute.
The private respondent making construction over the land, your lordship, of the petitioner residing at Howrah, regarding matrimonial issue, vacant land, with the local goods and corporation, your lordship, they are making construction over the petitioner lordship.
All right. Keep it forward.
Milord,
I am making construction under valid sanction plan.
Wednesday. Wednesday.
Sought to be invoked against my construction, my lord. They are saying.
Give it.
Milord, may I proceed?
Wednesday.
Milord, may I proceed?
Just a minute. I'm here, madam. Yes, tell me. Just a minute.
Milord, item number 266.
Yes.
It was early in the 224. It is a case of my proper loss of property, and it is a case of my death also, because the opposite party, they certainly with the help of the GUMS, they demolished our common boundary wall. So, my lord, please take this last.
Give your slip, madam.
I'm the cancer patient also. I am in the stage 2.
Give your slip.
Lordship, item number.
Extension
Give your slip. Give your slip.
Lordship, may I be part?
See,
Lordship, item number 249, eventual Lordship.
Give your, what is it?
Agency eventual Lordship 249, eventual Lordship, the demolition order was first, eventual Lordship. The petitioner filed the statutory appeal, eventual Lordship. Keeping pending the appeal, they want to demolish.
Give
the-
your slip, we'll see.
Lordship, may I be permitted to mention one for withdrawal of an application, Lordship, item
Give
number
your slip, sir.
Lordship, this is for withdrawal.
Withdrawal, give your slip.
Read petition, my lord, lordship, give me liberty to file afresh due to having some mistake, my lord. There is a lordship direction, there is a unauthorized construction, my lord. Already it has been settled, my lord. My lord,
Yes.
lordship, give me liberty to file afresh due to having some mistake in the prayer portion that has been complied, and read has been filed, my lord. Kindly, my lord, if possible, my lord, it is item number 2968 of month list of September, my
Give
lord.
your slip, we'll see.
My lord, may I be permitted to mention a matter for upgradation?
Just a minute. Yes, Mr. Adalji.
My lord, item number 60 of your lordship's list.
Yes.
My lord, I had heard this matter earlier. The private respondent has 17 criminal cases pending against him. He's a history sheeter. My lord, on a piece of land, he built a G+3, including the government pond, which is next door. He took
Yes.
half the pond and he built it. Your lordships dealt with this matter. It went up in appeal. It came back to your lordships. The lordships were pleased to direct the corporation to take a final decision with
Yes.
regard to the demolition, whether it was an illegal construction. Now, the order has come from the municipality that it is a complete building is illegal. And just because he belongs to a particular political dispensation, my lord, nothing has been done till date. So, my lord will kindly,
Who are you appearing for, Mr.?
I am appearing for the petitioner. My lord, if your lordships can kindly fix any date as per your lordship's convenience.
This side of the vacation will be difficult.
My lord, even if that side of the vacation, if your lordships kindly
Just give your slip, we'll see that.
Well, may
extremely grateful, my lord.
my lord, should I submit all the papers also?
Madam,
Except the photographs and.
My lord, may I be
Madam, may I be permitted to mention, my lord, Madam, may I be permitted to mention, my lord, on item number 58 of your lordship's leaves. Urgency is that, my lord, challenge is that, my lord, we challenge 401 proceedings by the KMCA. One notice was issued under 401 that was recalled by the KMC that no unauthorized construction is done by the petitioner. Subsequently, against with the same allegation, they have again initiated 401, which challenge the writ petition. During the pendency of the writ petition, whether they now wish to a 401 notice to my advocate on record, in the name of advocate on record by the KMC, and kindly see the notice and kindly see that Rahul Dev Goenka is.
so maybe even he has a property which is illegal.
No,
Then
he's a junior member of the body, advocate on record. Now he is saying that he is making the unauthorized. Kindly see the notice.
we'll see that.
My lord, may I be mentioned?
And kindly see that I will notice I have mentioned.
We'll see that.
Yes.
Take that slip.
My lord, may I be permitted for upgradation in the list? My lord, the matter relates to municipal election and it is listed as item 677 under the heading motion to municipality. And the Rishta municipal elections are coming soon and the matter has been pending for a long time. My lord.
Give your slip.
Grateful.
And last week of the vacation, huh? Last week
My
of
lord,
the
it has been
vacation.
pending for a long time. That's
So, were you sleeping?
no, my
Then
lord, earlier also I had mentioned, but it was not listed.
My lord, on 4th September, this writ petition was heard by the Honorable Justice Ravi Kishan Kapoor, my lord, substantially, my lord.
very good.
And my lord, the direction of the affidavits were passed and
Very good.
time has already expired. Liberty has been given to mention before your lordship, my lord.
Very
There
good.
is an unauthorized construction, my lord, ongoing. If
Give
the,
your slip.
my lord, if your lordships is heavily burdened, if this can be released, my lord, that is on instruction.
Go and mention before the Honorable Acting Chief Justice for release of the matter. All right? Give the slip if you want to.
Kindly permit, I would like to mention a matter for upgradation. My lord, in your list of item number 170. My lord, in this matter, the petitioner have all type of legitimate documents to prove the right of title, but the respondent authority is not recording the name, and hence the petitioner is sitting idle as he cannot for the proceedings.
Give your slip, madam. We'll see.
There
Yes.
all of the land firm up by the same lordship due, installation of pumping station.
Give your slip.
My lord, may I be permitted to mention for upgradation?
Give your slip, sir.
For updating, my lord, I'm an employee, my lord, I'm not with them. My lord, gratuity, my lord.
Give your slip. Give your
To mention, my lord, but inclusion, my lord.
Give your slip.
May I be permitted to mention one matter? See, the item number 42 of the combined list, okay, there is an order of demolition. And when against the order of demolition, the respondent authority filed an appeal. That appeal has also been dismissed, but the demolition has not been carried out. So, my lord, the petitioner then filed an application contempt before the Honorable Justice Singh. But the contempt application could not be listed because the restriction to lordship.
Contempt has got nothing to do with the list. You withdraw this.
Petition before the leadership is saying that without petition the contempt appeal cannot be heard. But I thought this
You withdraw it.
lordship,
You want to withdraw it? Withdraw it.
but then I have to not release or not to hear out the restriction.
Give your slip.
My lord, may I be permitted to mention item number 294 of monthly combined list. The urgency is that, my lord, due to the action of the private respondents, but my ceiling has been wholly damaged. The cluster has been falling under section 231 of the West Bengal Municipal Act. The municipal.
Give your slip. Give your slip.
With my lord's leave, may I permit to mention, well, this is the second round of gives some precedence. But this is second round of litigation,
Yes.
your lordship.
Have you permitted for upgradation?
Give your slip, madam.
Well, for upgradation.
Lordship, may I permit to mention the matter for upgradation, Lordship?
Give your slip, madam.
Mentioning for inclusion.
All right. Call out the list.
Lordship,
Yes, ma'am.
Lordship,
Okay.
Lordship, I'm mentioning for upgradation, Lordship.
Give your.
I am for the petitioner.
Reconstruction of CAM. रिकंस्ट्रक्शन हो गया ये लर्नड क्वेश्चन ने क्या लिखा है ये तो चिट्ठी है Yes.
Petition for the petition.
Yes.
Lordship, the application for restoration was misplaced. Subsequently,
Yes.
it has been reconstructed as per order of your Lordship. Lordship, matter regarding family pension of Navadvip municipality. Lordship already has had several matters in this regard.
Your can one is what for
Regarding
restoration?
restoration.
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 You place it again. I'll pass an order.
There is no delay, Lordship. Only after dismissal.
That's right, but the your can has been misplaced.
Subsequently, I have submitted the can application before the
It
department.
has to be authenticated also.
I have already authenticated.
You have done that?
I've done it. By putting my signature.
Has the new copy been placed on record?
Lordship. In the mandamus department.
पैन का कॉपी का और इसका reconstruction का order बना दो. Learned counsel for the petitioner states that the can one has been authenticated and has been filed again. There's a note from the registrar administration which states that the can application was misplaced. Full stop. Let the file be reconstructed and placed before this court on Wednesday.
There should be
Along
any
with the
short
can
date maybe.
application. Wednesday.
Deeply obliged. Top बोलते हैं मैंने top ही रहा है.
Hmm. ग्रुप चेंज नहीं हुआ तो यहाँ कैसे आ गया? Unless until the group.
Yeah, yes, my lord. Actually, the Justice Judge Sengupta released the matter because of lack of determination. There is erroneously recorded.
Madam, it has to be the determination has to be corrected. It has to be filed
my
in
lord,
Group 5. Where
my-
have you done that?
My lord, the file.
Just mentioned it like this before me.
My lord, leave may be granted to do the correction, my lord.
You don't need leave. You should have just gone there. You should have taken the leave from the court where you had mentioned it.
My lord, I'll do the.
Don't mention matters like this.
My lord,
The
my lord, today itself I'll do the correction.
this matter was released from the this matter has been filed under Group 9. The same was released by Honorable Justice Jayasin Gupta for lack of determination. This matter has been.
Lordship, I am appealing under the state.
Petitioner is given liberty to make the appropriate changes and file it. Make appropriate changes.
Lordship, I am appealing under the state respondent.
My lord.
for the Kamluk municipality, Lordship.
Just take down. The present writ petition has been listed on mentioning, even on the earlier occasion. None appeared for the petitioner. Today also there is no appearance on behalf of the petitioner. It seems the petitioner is not interested in pursuing the present writ petition. The same is dismissed for non-prosecution. Non-problem.
For your Lordship, I'm appearing for the petitioner. Your Lordship, there was a direction to file such report. Your Lordship, I have also filing an exception to such report. Lordship, may I also be permitted to file the affidavit of service for CAN 2, the extension, the application for extension. CAN 2.
Take down. The affidavit in opposition filed by the Calcutta Municipal Corporation is taken on record. Exception, reply to the affidavit. Report by way of an affidavit. Exception to the same, report by way of an affidavit filed by the claims taken on record. It's only a report affidavit. Report filed by the KMC is taken on record. Exception to the same is taken on record. Exception filed by the petitioner is also taken on record. Full stop. CAN 2 is for your extension.
No, CAN 2 for extension. Lordship, the order is at page 13 of CAN 2. 23rd July 2025.
Yes. You want to argue it today, you tell me.
Lordship, Lordship, I'm praying for only a extension, your Lordship, with regard to your Lordship, the order which was passed on 23rd July.
That's right.
Since your Lordship, a direction was passed upon the KMC, Lordship, the first paragraph. Let the corporation file an affidavit disclosing the documents pertaining to the apportionment of tax liability of the petitioners and the communication of the same to the petitioners.
Which they have done now.
Lordship, in this application, in this whatever they have been directed to file, no documents with regard to apportionment has been filed till date. They are claiming the tax for an entire building. I'm only occupying 3,000 square feet of one floor. That is my grievance. Considering the same, Lordship, when the writ petition was filed, the matter was pending. And in the meantime, during the vacation, in the month of May, they had come to the office premises of the petitioner.
Show me the
tried
report.
to, Lordship.
Show me the report from the report.
Lordship. Lordship, this is the KMC's report.
Yes.
Which is affirmed. The direction was to file within a certain time period, but it was served upon me after that. Lordship, there was a delay. It is...
That's all right, madam.
Lordship, to this I have used my exception. Lordship, since the direction was to furnish the documents pertaining to which they have come to this conclusion, even if 1 rupee is the tax, even if 1 crore is the tax, our principal grievance was that give us the calculation. And they are raising the calculation in the year 2005 of some, they're saying some last 40 years, no documents. That was our only grievance. And we have already paid them 1 crore 40 lakhs.
We have issued a notice to them.
That was
asking
never
for
received by us.
Just a minute.
Yes,
Madam,
yes.
Where have you followed the direction of the court? What are the documents you have placed on record by which you are raising the taxes?
Lordship, I have given a chart in page number 8, para 11.
Help. How is the apportionment being calculated?
Lordship, I have stated that in respect of 3
Where is the document to that effect?
Lordship, kindly see
The order is very clear, madam, that you have to file documents.
Yes, Lordship, whatever, because I have stated before this,
Where are the documents?
I've-
Why your report doesn't carry those documents? That how have you?
I have annexed the letters and I have annexed the notice, hearing notice. They have not given any objection to that notice.
So where is the order which has been passed? If they have not given any hearing, they didn't come for the hearing.
Lordship, first of all, Lordship, kindly see page number 11.
Yes.
I have given a letter which in their exception that they are saying they have not received.
That's
I have
all
got
right.
the copy of the service return where they have received.
All right.
They have chosen not to file any document. Therefore, in terms of the section, in respect of the flows where there was no payments of tax, I have apportioned it.
That's what I want to know. How have you apportioned it?
Lordship, the taxes, Lordship,
Show me
kindly
from
see.
your document, madam. Show me from your document.
Kindly see page number 18.
Yes.
'18 and 19, the way.
Yes, show me. Tell me the document. Explain from the document. How have you done it?
It's a 2024, 2025 document. Lordship, right-hand side top.
In respect of the flows where the owner has not given any property tax,
Yes.
that has been apportioned amongst the occupiers. The occupier's name is written as PLPT.
Yes.
Left-hand side, Agorpara Jute Mill.
Yes.
Then below, Venkateshwar, Vanijya India Limited.
Yes.
And the page number 19, Shrilekha Banerjee, Jayanto Banerjee. And below that, one more column is there. And the calculation is there on the right-hand side.
This is your 2024.
Yes, 2024.
Where are
We
the-
have apportioned from 2024.
Only for 1 year.
24 we have apportioned. Kindly see the notice.
The notice is also 2025.
Page 16, hearing notice.
Yes.
Effective quarter with effect from fourth quarter 24.
So you're only asking for 20,
Yes,
24,
yes.
25.
Yes, no. And the letter of intimation on the basis of the valuation, the earlier valuation which has not been paid, that valuation was done long time back. Only the apportioned tax has been asked. And Lordship, they are saying they have not received any notice. I have got the service refund. If your Lordship can see the service returns.
Don't need to, madam. If they have not participated in the hearing, they have not
They
participated.
have chosen not to.
That's all. That's none of your concern. Where have you passed the order? Where is the order?
Lordship, when an SSC hearing notice has been issued,
Yes.
when a SSC chosen not to give any objection,
There's an ex parte order which you would have passed, right?
not ex parte, when the SSC chosen not to give any objection, the assessment, the annual valuation which are proposed has been confirmed.
So, madam, are you only charging for 24, 25, or it is previous years also?
Lordship,
There needs to be an order which-
the assessment has been made in respect of 24, 25, and the letter of intimation, the taxes, if 100 rupee was due, it has been in respect of 4 floors. If 100 rupees was due, it has been apportioned amongst the 4 occupiers. If your Lordship asked me to produce, I can produce once more the chart.
Please produce the chart.
Yes, I will produce.
Learned counsel for the petitioner, respondent, KMC, states that seeks and is directed to file an additional affidavit complying with the order dated, which is that order?
Lordship, 23rd July 2025.
23rd July 2025, wherein the documents pertaining to the apportionment of tax liability of the petitioner shall be placed on record. full stop. In the meantime, the can two kar do.
Can two.
The interim order granted earlier. This is an application filed by the petitioner for seeking extension of the interim order. Interim order granted earlier is extended further for a period of 8 weeks or until further order, whichever is earlier. With the above direction, can two is disposed of. List this matter after vacation.
Grateful, my lord.
Seeks and is granted time to file additional report. Taken.
Grateful, my lord. Can, Lordship, can one have filed as an application for appropriate order, giving the details of the development which took place when the writ petition was
Can
pending?
dispose it of.
Lordship, kindly hear. Here's can one, your lordship, on the next date, your lordship. It contains all the details. Can one that happen? Grateful, my lord.
I don't know 5 and 6 in this matter.
For 5, I'm mapping the state of West Bengal.
Already in item of 5 and 6, Mr.
Where's Mr. Nag?
No evident opposition has been sought.
Yes, my lord, the affidavit in opposition is ready. Only the affirmation is left. Kindly keep it on Wednesday. By Wednesday, we will file the affidavit.
My lord, may I say one thing, my lord?
Not today.
We have already submitted our affidavit.
My lord, we have used our reply. It is a very serious question of law involved in this matter. If your lordship, my lord, takes up the matter after vacation, your lordship, they are not final.
No, my lord, by
We will
Wednesday,
we will file
the
a reply.
affidavit. Sure.
We will file a reply. They are not in terms of your process problem direction.
They are saying that they are filing by Wednesday.
We shall file reply and your lordship kindly extend the time.
Well, let them first file it, sir. They have not filed it. They are filing it on Wednesday.
And my lord, earlier there is direction for reply. There is a direction for reply also, my lord.
First, let them file the affidavit, then only you'll file the reply. Or you'll file the reply before the affidavit also comes in.
No, they filed the earlier there is a direction that both the respondents shall file their evidence opposition and the writ petition shall file reply.
Yes.
And 2 of the respondents, my lord, filed my lord evidence opposition, we file our reply.
Yes.
Now the municipality main respondent, my lord, they will file the evidence opposition.
That's what she's saying.
Right, your lordship, extend time, but we may be permitted to file reply.
Obviously, you have a right.
All right, my lord.
Lordship is extending the time.
Wednesday. First, we'll have it on Wednesday. Let's complete the, not today, Wednesday.
এই নামগুলো ছেড়ে দাও না।
Wednesday.
7-8 আছে না?
Hold on. Hey, Petition. Hey, Petition, no.
I appear for the petition. My profound apologies for the last occasion, my lord. I ought not to have appeared on virtual mode after having mentioned the matter for upgradation. Lord, please accept my apologies. My lord, there are 2 writ petitions, my lord. The first one, my lord, I'll be withdrawing subject to my lord's leave because the second one is the more comprehensive one. In connection with the second one, my lord, there's an application, a CAN application, which we filed. That's CAN 1 of 2025.
Let's take down first. You're withdrawing 18925.
Yes.
তুমি সাথে না দিন।
15427 of 2025. So
15427.
that's item 8. I'm so sorry. That's item 8. 15427 of 2025.
Learned counsel for the petitioner seeks to withdraw the item 8, present writ petition. The same is dismissed as withdrawn.
ভালো হলো বেঁচে গেলাম। 8টা উইথড্র করে দিয়েছি বেঁচে। এই 8টা উইথড্র করে নিচ্ছ? 115? হ্যাঁ। ঠিক আছে।
My lord, this is in connection with, my lord, the Ohio hospital, which is functioning from Newtown. The building was made, my lord, in compliance with all sanctions and permissions. Hospital was operationalized. An annual valuation exercise was done on the basis of a self-assessment form which we had put in. Pursuant to that annual valuation exercise, my lord, we have been putting in regularly paying, my lord, the property taxes till date. There are other licenses which are grantable in respect of the hospital, which have been granted in our favor and renewed. One of these licenses, my lord, is a medicine license for running a pharmacy. The other, of course, is the hospital licenses, and all of them are being renewed. And because it's within the NKDA's jurisdiction, a certificate of enlistment or a trade license is also issued. That's also renewed. The system of renewal is that the trade license renewal application is put in immediately after the previous financial year is over, and they take 1 or 2 months to process it. Thereafter, they send a demand. After that demand is put, my lord, through the portal, then the trade license comes in the form of a receipt come consolidated receipt come grant. That's how it's done. Now, my lord, when we had put in the trade license renewal application for the financial year 2025-26, sometime in April 2025, then, my lord, we came to discover that the NKDA was suggesting that there are certain property tax dues. Now, these property tax dues suggest that a higher quantum of tax is being charged from a retrospective period 2018-2019. This we came to know, my lord, after we found.
Since my lord 80 is withdrawing, but I'm for the state, but I'm leaving.
Please accept. Show me the due. Show me the due. Yes. Please come to, my lord, page 150, my lord, of the writ petition. Please come to 150. Now, my lord, if your lordship sees, this is what was shown in the portal at page 150. My lord sees, my lord, to the left column, first quarter 2018-2019 to fourth quarter 2024-2025. It has been shown as previous. Now, this is an assessed tax of 1,63 lakhs and odd, with a penalty amount of 36.26 lakhs to be paid within 30th of April 2025. This is the previous demand which we are shocked by, because if your lordship sees, the regular demands that were coming earlier, we have been paying. And the payment of the regular demands, my lord, we have annexed all the payment receipts. For instance, my lord, at page 114 is one of the receipts. We have given all the receipts, my lord. Kindly see, all of them have been deposited within time. Our payment of taxes are completely, my lord, up to date. And all of them have been paid through the property tax portal. As and when the demands have been raised, we made payments. Now, my lord, this coming back, my lord, to page 150, it appears that they have now made a retrospective assessment of annual value of the property. It may be pursuant to their scheme of unit area assessment. My lord knows that the Kolkata Municipal Corporation Act has this unit area assessment. Bodily, these provisions have been, with very slight changes, lifted and inserted into the NKDA Act by amendment of section 36A to 36 ZC. So, my lord, it's been bodily lifted. The entire annual valuation chapter, assessment chapter, has been bodily lifted. After this has been done, perhaps they have made, my lord, an assessment of the unit area value of my hospital. Earlier also, there was an assessment of the unit area value pursuant to my self-assessment on which I was paying. What they have done is, this assessment which they have now made, they have served up bills and they are showing that these bills are in deficit and charging penalty of 36 lakhs for a bill of 1.63 crores. Now, to this, we have only two submissions. One is, assuming that they can make it today at a retrospective point of time in 2025 for 2018-19, they ought to have given us an opportunity of hearing if they are making it, so that we could have reacted to whether they have the correct figures on board for the purpose of the statutory formula. This they have not given, and this I don't think Mr. Ray will dispute the fact that this has not been given. Secondly, insofar as the taxes are concerned, they are showing these
purported taxes due from a retrospective period and charging penalty. Now, in my respectful submission, no bill containing any of the amounts pursuant to the retrospective valuation has ever been served upon us at any prior point of time. It's only when we sought renewal of our trade license in April 2025 that for the first time, this demand was flashed on their portal. We went and we spoke with them. Subsequently, they revised the demand, and for a while, this demand was taken off. Again, it has come back to the portal. Kindly see, page 153 now. Page 153, annexure P13. It appears from our office records that property tax against the instant assessment number has been lying unpaid. The details of outstanding property tax penalty and the last date of payment are furnished below. If your lordship sees, again they are reflecting the same demand. First quarter 2018-19, payable amount is 362559. They have calculated a penalty under 36(1), and the entire sum is now being shown as 2 crores and odd, 2 crores 7 lakhs, 2 crores 7 lakhs 27,000, out of which, my lord, 86 lakhs will be penalty. This they are, my lord, showing now on their portal. Now, Mr. Ray would perhaps argue that in a unit area assessment system, there's just a formula. There is no requirement of giving the assessee an opportunity of being heard. To which, my lord, my humble submission would be that here I am affected, I have an adverse civil consequence. Therefore, to see whether the components of the formula are have been properly computed or not, at least, my lord, my and my experts' participation was necessary. Second, after the assessment, there has been no communication of any order of assessment to me so that I come to know the manner or mode in which they have come to the figure. Third, they have issued bills. They have issued demands without issuing bills at the contemporaneous point of time. Today, these demands they are showing as unpaid. And as a result of that, 86 lakhs of penalty are being charged from me. Now, these are the three grievances on which we come before your lordship. The urgency is this matter was waiting its queue. And my lord, we had earlier mentioned, but my lords were pleased to say that unless there is a pressing urgency in terms of lordships may not entertain. This pressing urgency came in Can 1 of 2025, which your lordship will see. My lord, our medicine licenses are dependent on the trade license granted by the NKDA. Once we give them the trade license, then our medicine license is renewed. If our medicine licenses are not renewed, our pharmacy is closed. And if our pharmacy closes, a large part of our operations will have to close down because these contain important life-saving drugs available in situ. Now, my lord, when we had, my lord, when we were, my lord, following up with the authorities concerned, at page 184, this letter has come to us, my lord, from the medicine license department, page 184 of the Can. Last annexure, annexure C of the Can. From the Superintendent of Excise to Ohio, subject required document is sought from Excise Directorate for renewal of MD3 license. That's the medicine license. Gentlemen, with reference to the above noted subject, I am directed to inform you to submit the following documents. Number one, copy of valid trade license for the financial year 2025-26. So this has to be granted by NKDA. This is a condition precedent for issuance of the medicine license. Now, NKDA will not activate the portal for renewal of the trade license until I make payment of what they perceive to be the arrears. Now, this is where I am. I am ready and willing to make appropriate payments, my lord, in accordance with law. There has not been a single case where I have, my lord, defaulted in payment. But if this situation is not addressed, then, my lord, my hospital will close down because, my lord, technically speaking, I am tethering at the brink of default in terms of licenses because though these applications have been taken, they are yet to be renewed. We are in September 2025-26, my lord, we are precariously placed. My lord, these are my submissions.
Yes. And the last submission, I would like to have a clarification. I do not understand. He said, I'm ready and willing to pay whatever I have to pay in accordance with law. And if he is agreeable to pay, my lord, I will have no problem. Now the problem is, my lord, what my.
So what we can do in the meantime is,
My lord,
probably they can make the payment, you give them the offer,
sorry, I'm missing.
give them the offer.
Come, my lord.
Offer in the sense, they can make some payment, renew the trade license in the meantime, and we can keep this pending. We can hear the.
Yes, my lord, let them put in the entire amount.
Entire amount.
And I'll point out why, my lord. May I just make my submissions then, my lord? Two things, my lord. A few, I wouldn't say my learned friend has made the suppressions. The suppressions are from his client. My lord kindly appreciates what they're trying to say. My lord, they are saying it's a self-assessment. But I have understood what fell from your lordship, but I'm now trying to only, my lord, substantiate why I'm asking for the full amount, my lord. Kindly does not take me that I'm not accepting your whatever is falling from your lordship, my lord. But when in 2018 they make the self-assessment, they say it's a G+8 floor building. I can show it from the document, my lord. Your lordship will find that the building area, my lord, is only the land area, so it's one floor. But on that day, my lord, they knew that there were 8 floors and which did not or were not self-assessed. So today, my lord, when the self-assessment is being done, my lord, after that, my lord, we have a provision, my lord, under the Act itself, my lord, which allows us to relook into this assessment. Once that is done, my lord, I issue this notice. Because when it's portal-based, with what Mr. Banerjee said, he has wrongly been instructed, my lord, the entire calculation is on the portal. I mean, my lord, but as a matter of fact, I've also made a chart as to from which my lord, floor for what amount, my lord, it's available on the portal. And I have made it from that, my lord, I can hand it over, but he can go to the portal and have a look at it. But I'm not showing it to your lordship for the time being. So, my lord, the tax amount is that amount. Now, my lord, here is a person whose trade license, my lord, expires in March 2025. He makes an application on 2nd April. After that, my lord, all quiet. Nothing done. He continues with the hospital without any trade license. We have not stopped him, but he continues. Now, my lord, he files a writ petition, which is pending before your lordship. Nothing done, my lord, with regard to the tax. Now, 5th August, my lord, I give him this notice. And today, my lord, sudden urgency comes because he doesn't cater to my notice. Because there's a notice from the department, my lord. Now he has come that no, it will come to a standstill, my lord. My lord will kindly consider this, that he has a right, which is there in the Act, my lord, to file an objection. And that is 36S, 36R, and 36S. Now, when he files that objection, my lord, that is when he gets a hearing. He has not availed that. He has just come before your lordship. My lord, now the question is, he has availed an alternative remedy before your lordship. My lord, whether your lordship would go into that, considering 2 things. One, my lord, that he himself has been acting illegally. I'm sorry I'm using that word, my lord, because he was well aware that he had 8 floors which he had to get self-assessed. One is that. Second, my lord, he comes before your lordship and keeps quiet for such a long time and does nothing about it. Now, my lord, in the provisions also, my lord, he has lost the hearing chance, my lord. If your lordship, obviously your lordship will direct, I will obviously give that. After that, my lord, the question of appeal, my lord. There also, my lord, the question is putting in the full amount.
In the appeal?
Yes.
Sorry?
Appeal provides for that. Full amount with penalty. That is why I'm submitting before your lordship, that if your lordship is entered, obviously your lordship fell. I understand the urgency, my lord. I'm sure, my lord, if it was not a question of a hospital, my lord, this wouldn't have fallen from your lordship. I do appreciate that also. My lord, if I would have asked them how many patients you have got, that would have been also a very difficult thing for them to answer, my lord. I will not go into that, my lord, how much that hospital is running, my lord. We are well aware of what is happening there. But I'm not on that. The point is, my lord, he's trying to avail an alternative, he's trying to avail your lordship's jurisdiction by overcoming an alternative remedy where at one stage they will have to put in the entire amount. I'm saying, my lord, let him put in the entire amount before your lordship's court. And I will give them a provisional license, provisional trade license, subject to your lordship's order, my lord. I mean, final outcome, my lord, of this. I can do that. But they must put in the entire amount. Because, my lord, kindly appreciates from 2019, my lord, this is going on for a self-assessment. They had every chance of, my lord, reassessing themselves. They could have made that. But let us say today, my lord, what happens? In, let's say, 2018, my lord, they have 2 floors. Self-assessment for 2 floors, they're done. After that, they are entitled to build on that. If they build further, they have another chance of making another self-assessment for the extra floors. They don't do that. I'm questioning, my lord, a person coming before your lordship with unclean hands. He should have
Mr.
expressed
Banerjee,
that.
tell me one thing, that if we accept the arguments, then in that scenario, you are well aware that these are the amounts which are being raised. You are well aware because it's a self-assessment scheme. Unit area method is a self-assessment scheme. So you are basically doing everything, and when they see that it is not being done
Properly,
honestly,
yeah,
properly,
yes.
you know,
They make a
then
retrospective.
they can make a retrospective inquiry into it. Now, all this information, what Mr. Ray
Ray
has
has been
handed
saying.
over,
Yes.
if that is correct,
Mhm.
then you should have asked for a hearing.
Yes, no, I'll tell you, Lordship. I bow down to my Lord what has fallen from your Lordship. I am also grateful to Mr. Ray for pointing out the statutory provision. Please have a look at section 36R and the notice which we've got. Please have a look, my Lord, at section 36R.
May I then read section 36R along
Before,
with your lordship?
yes, before that, my Lord, if Mr. Ray has finished, my Lord, then I can respond.
No, he's saying he's just reading out section.
May I see, my Lord, also place, my Lord,
My lord,
section 30.
this is what-
I guess, my Lord, both are 36 hours are same. So let any of us assist your Lordship, my Lord. It could be.
You were,
Fine.
but he has given my book to your lordship.
I'm so sorry, my Lord. He can sue me.
But as a matter,
He can sue me.
but as a matter,
can sue me.
we have been in the college. from
We
the
have been
same
in the
batch.
college from the same place, and our Haryali in terms of figure is because of the fact that we used to have two special biryanis back to back, and while waiting for the biryanis to be served, we used to get out of the shop, cross the road, have two special anda chicken rolls, and come back. This is
Those were the days.
not the source of our combined plenitude, Lord. Now, Lord, I'm coming back to 36R.
Yes.
I am at one with Mr. Ray when he suggests that the earlier assessment may not have been proper, because if the assessment does not show the correct picture, then automatically they are at a liberty to reassess. I have materials to show that the entire picture was given, but that is neither here nor there. That by itself is a disputed fact, which I may not take your lordship into at this stage. All I'm saying is, in the event they make a proposal for retrospective assessment saying that this is the correct figure, then they are required to give us a notice. This notice never came. Please come to 36R. This notice never came. As an amendment of assessment, the development authority may at any time make suo motu an assessment in any case where a return on the basis of self-assessment has not been filed, not our case. Please come to C. Let's take Mr. Ray's case at the highest. Reopen any assessment at any time.
Paramateria event to the municipal corporation.
192. That's section 192.
Even municipal corporation.
KMC Act.
Even Delhi municipal.
Even DMC. Yes.
Same.
So
absolutely.
And all these have been taken from the London statute. So my lord will find even the commas are same. C. Reopen any assessment at any time where it has been detected that there is willful suppression of information. Now, my lord, that is a power available, saddled with a condition precedent. Please come to the proviso. Provided that in case of such determination of valuation, a notice stating the proposed valuation shall be issued to the owner or to any lessee, sublessee or occupier of the land, or the land comprising the building or the buildings or the portion thereof, and such notice shall specify the place, time, and date not less than 1 month thereafter, when the development authority or the representative will proceed to consider such valuation, provided further that no public notice need be given in such case. Otherwise, for ward-wise assessments, there's also a requirement of an additional public notice. So this has to come in. My lord, on the municipalities' prima facie assumption that there has been fraud or suppression of details, they can't go ahead and make an assessment and then serve me the bill. That's what they have done. Please have a look at.
No, but that is not how I read it.
May kindly see 36ZC just once what they have done.
But your reading of 36R is slightly different, because if you see if the authority in 3 scenarios, one is suo motu, the other is revise, you fall in C. Reopen any assessment at any time where it has been detected that there's a willful suppression of information, provided that in case of such a determination of valuation, a notice stating the proposed proposed valuation shall be issued to the owner or any lessee, sublessee or occupier of the land or the land comprising the building or the buildings or the portion thereof. And such notice shall specify the time, place, date, not less than 1 month thereafter, when the development authority or the representative will proceed or consider such valuation. So they have given a notice.
They have given us a demand. Please have a look at the two things that they have given. I'll show for your lordship straight away. Please have a look at the first document where they mention this. Please have a look at my writ petition. Please take a look, my lord, at
The
page.
determination of valuation would be anything which has not been, which has been willfully suppressed by you.
The entirety of what they say,
Correct.
vis-a-vis the entirety of what we have put. Now this has to be.
And the notice is basically the proposed valuation which they are giving you.
Yes, the proposed valuation and a right to object. Now, my lord, these two are not there. Please have a look at the first time we came to learn of this. Please come to page 151 of the writ petition. Page 150 of the writ petition. Please, 150 of the writ petition.
Their writ petition is not complete, my lord. I must then point out that, my lord, many documents.
My lord, I am still replying. I'm still replying, lord.
Then I will, my lord.
Then that's very fair. Fair enough.
Hold on.
Fair enough. There's no difficulty. I didn't ask for a half hog.
No,
Please, page 150.
No, but can we find, because
my lord, the better thing
Mr.
is,
Mr. Banerjee, there is still a provision for you where you can go back to them with your
grievances.
If you want to shut that and you want to just be before the
No, I
court.
don't. What I want,
So
lord,
what I can do is I can remand it back. They will consider all your objections. In the meantime, you deposit the money.
I'll deposit the entire principal to show, my lord, my bona fides, not the penalty, my lord, with great respect, because that penalty can only come in when there's an outstanding bill. There's no outstanding bill as of today. I'll deposit the principal. I cannot run a hospital by only, my lord, making counsel submissions at the bar without money being put in. I'll deposit the entire principal that they are showing, not the 80 lakhs of penalty for the time being. Let them hear me out on the proposal.
If the provision itself says that the entire amount has to be.
That's in case of appeal. That's in case of appeal. Here they have not given me an opportunity at the first forum. So I come within the third exception of one pool.
Oh, sorry. I'm sorry, my lord.
This can be, put your thoughts to this, that we remanded back. All their grievances can be addressed by you, subject to them depositing the entire principal amount, bereft of the interest, penalty. And you consider it.
If that can be done,
And in the meantime, you grant them the
opportunity of hearing. In the meantime, let them grant the trade license so that otherwise we won't get the additional license.
But I'm taking instructions, but I'm being told that it wouldn't be a problem if your lordship makes that order, my lord.
Then, my lord, I think we.
Instruction আর কোনো instruction নিতে হবে না তো?
Yeah.
But after I
সেটা
get
ওটা
the
বলছি।
order, I'm very wary about instructions. That can be done, my lord.
But then, my lord, their loss is our gain. So when he comes this side, my lord, it's easier for us, my lord. We can go to Mr. Ray, and Mr. Ray's fairness can also come from this side.
This might come back again also. You never know.
He's in
Enough experience on that. Not anymore.
I'll cut short the issue then.
Yes, my lords.
Then I'll cut short the issue.
Yes.
My lord is keeping the repetition pending.
Why should I keep it?
My lord, then you're not, if the objection, my lord, if we find that objection is fine, and then we'll proceed and, my lord, impose the penalty and take order.
No. I mean, subject to their giving me an order, subject to my right to assail. Naturally.
Now, which is that provision?
Mr. Ray is trying to. No, my lord, subject to correction, my lord. My lord will leave it open to me to take appropriate steps in accordance with law. If I bypass the appellate provision, come to your lordship. Lordship will haul me up.
But only thing is, the license shall give them will be provisional at the meantime.
Why? Please. Yes. This provisional thing will, my lord, it will put my medical thing in jeopardy. Let the trade license, I'll tell you, lordship, the moment it is made provisional, they will say this is not an absolute trade license. Another round of litigation will start.
They should not have any problem.
I am appealing to Mr. Ray.
Mr. Ray, I'll tell you the problem will be.
Let it be
the
given.
problem is that this is for the renewal of the medical
license, like the shop. We won't.
Now they can face that problem that tomorrow that authority would say it's a provisional
if the
license.
provisional license is not final, we'll not give you. Please.
But then your lordship will kindly keep some kind of a protection that in the event we find that they are required to pay the penalty and the entire tax.
Subject to our challenge.
We will have a right of considering a cancellation.
You always have the right.
That's always
of the
there.
trade license.
That's always there.
Makes that provision.
That's always there.
Which is that provision where they can be sent back the objection? Yes.
36R never came, according to us. 36R notice didn't come. So, but my lord will be sending us back for 36S objection for hearing before the appropriate authority under 36U. S is the objection, 36R is the notice. And they gave us notice, they gave us a demand under 36ZC, which is the state subsequent.
If you want to.
No, why get into?
Let's go there.
No, I am ready to go there. No difficulty. I'm not shirking.
Shall take down.
If you want, I can go anywhere.
The petitioner has preferred the present writ petition being aggrieved by the alleged retrospective assessment carried out by the respondent corporation in respect of petitioner's premises bearing number 10/03333, action area ID Newtown, PS, Rajarhat, Calcutta, full stop. Calcutta, sorry, and the consequent demand notice dated 8/8/2025, along with the purported demand of property tax and penalty reflected on the respondent's online portal. Full stop. The case of the petitioner is that they are the absolute owners of the said premises by virtue of a registered deed of conveyance dated 2/1/2008 and have been running a hospital therein since 2017, right? The petitioner constructed the said building in accordance with the building plan, which was duly sanctioned by the respondent corporation on 3/6/2014, and the occupancy certificate was issued on 3/3/2015. Full stop. The petitioner has been running the said hospital and have been filing the property tax under the self-assessment scheme, and wherein the petitioner self-assessment scheme.
We've been making payment of property taxes from time to time on that.
Full stop. It is the case of the petitioner. Learned counsel for senior counsel for the petitioner, Mr. Arindam Mukherjee, states that the petitioner has been regularly paying the property tax in accordance with such system generated demands from the year 2018 till 2025. Full stop. The last payment was made for the fourth quarter of 2025 on 28th March 2025. Full stop. He further states that the petitioner's trade license expired on 31st of March 2025. Full stop. For renewal, the petitioner attempted to apply online on 3/4/2025, but a purported demand of 1,99,38,556 was reflected against the outstanding property tax dues. Full stop. The said demand comprised allegedly of property tax dues of rupees 1,63,11,632 for the period covering the first quarter of 2018-19 to the fourth quarter of 24-25, along with the penalty interest of 36,24,424. Full stop. Due to the exorbitant demand, senior counsel for the petitioner states that due to the said exorbitant demand, the petitioner's trade license could not be renewed. Full stop. Learned counsel for the respondent states that the said assessment has been done under section 36R of the Newtown Calcutta Development Authority Act 2007. Learned senior counsel for the respondent, Mr. Ray, submits that the said assessment has been done under section 36R of the so-and-so Act. It states that since the petitioner had suppressed material, since it was detected that since it was detected at the time of filing of the property tax that the petitioner has willfully suppressed information regarding the self-assessment of the property, the said demand has been raised. It is further further argued by learned counsel for the respondent that the petitioner has not been paying the property tax in accordance with the provisions of the act, and there has been a material suppression of fact as far as the payment of the property tax dues were there. Full stop. Learned counsel for the respondent states that the petitioner is entitled to raise objections under section 36S of the act, and that he can still avail the provision of section 36A by raising the allegations as raised in the present writ petition. Full stop. Learned counsel for the petitioner states that the petitioner is ready and willing to go back to the respondent to raise his further objections in terms of the alleged purported illegal property tax demand which has been raised by the respondent respondent authority.
Lord, would your lordship say, Lord, objections to the proposed assessment, because demand is a condition subsequent.
Objection to the proposed
assessment.
Proposed assessment.
Target assessment will
Full
await
stop.
the result of issue.
At this stage, this court at this stage, this court feels that the objections of the petitioner can be well adjudicated upon by the respondent authority in terms of section 36S of the act. Full stop. Though in view of the same, the petitioner is remanded back to the respondent authority to address the concerns of the petitioner as far as the alleged
Proposed assessment is concerned.
alleged proposed assessment is concerned. Full stop. In the meantime, the petitioner also, the petitioner states that he is ready and willing to deposit the principal amount
Without prejudice
as raised by the respondent authority. Full stop. He states that his trade license shall be renewed since his medical licenses are dependent on the said renewal. Full stop. He states that he will not be able to, the operations of the hospital will not be able to function if the trade license is not renewed, and that will cause grave prejudice to the petitioner. Learned counsel for the respondent at this stage states that if the petitioner is ready and willing to deposit the said principal amount, then they are willing to issue the trade license to the petitioner, subject to the condition that after proceedings are held under section 36S and proceedings are held and still the petitioner is found to be suppressing material facts as alleged under section 36R, then in that scenario, the respondent corporation shall be at liberty to cancel the trade license in case the petitioner is unable to deposit the alleged demand raised by the respondent authority. Full stop. In view of this, in view of the statements made by the counsel for the parties, this court directs the petitioner to deposit the principal amount before the principal amount without prejudice before the respondent authority within a period of
1 week.
Within a period of 1 week, comma, after the deposit of the said amount, the respondent authority shall issue
Renew the trade license.
Shall renew the trade license. Full stop.
Not within 48 hours from date of deposit, not otherwise not.
Within 48 hours from the date of deposit of the said amount. Full stop. the petitioner shall approach the respondent within 2 weeks by raising objections under section 36S of the said act, full stop. The what is the process after that, Mr.?
The hearing officer will hear us.
Officer
That's
will hear,
36U.
and after the objection is undertaken, my lord, it will be heard and an order be passed. But once the order is passed, my lord,
then it's communicated.
Then it will be communicated and the appeal is, then
There's a question of an
appeal.
appeal or other challenges.
The-
Lord, only one prayer. 36R, they will give us a notice.
No,
We'll
no.
respond.
No, there is no further
The
notice. my lord.
proposal, the
No,
proposal.
there is no further notice, my lord. It's all on portal,
Hearing,
my lord.
hearing.
This is an
Fair
attempt,
enough.
my lord.
No attempt. I'm saying that
My lord, kindly see the notice.
I will treat their purported calculation in the portal as the notice.
My lord,
Fair.
yes, let them
Yes,
do
yes,
that.
yes, yes.
36R only requires that I'll be going.
Yes.
That notice
No,
will be-
that notice.
After the objections, the respondent shall grant a hearing in after the objections, the respondent shall
An acting term,
appoint
sorry.
act in accordance with the
Provisions of section
with the provisions
36U.
of section 36
U.
T also there is appointment of an
No, first T and U. T,
Huh.
there's already an officer on board. I'm sure.
shall act in accordance with section 36T as well as section
36U.
36U. Full stop. Before passing of any final order.
And they'll communicate the order to me.
In terms of 36(3), U3.
In terms of section 36?
36U3. They'll communicate the order. U subsection 3.
After the hearing, the order shall be communicated to the petitioner in terms of section 36 U3, right?
My lord. 36 capital U's within bracket 3.
U3. As prescribed under the said statute. Within 30 days, they.
Yes, with
Yes,
30
well, it's
yeah, that's prescribed under the CSS.
Prescribed under the.
And it will be open for the parties to take appropriate steps in accordance with law. Because that if I don't do anything, he can.
The petitioner shall be at liberty to file proceedings in accordance with law.
Challenging the said assessment if it is granted.
If agreed by the
assessment,
final assessment passed by the respondent.
Only one small thing, my lord. Oh, sorry. On 26, my lord, NKT offices are going to be come to a close. And
Ajay
again
Patari.
open on the 8th, my lord. So, my lord, if they have, they may.
Then you do it. That's for them. They should do it quickly.
That is what I'm requesting them.
Yeah, it's within 1 week, so we'll put it in tomorrow. If we can make it tomorrow, then give it within 26.
Make
Yes.
it 2 days, 2 days.
Yeah, 2 days, 2 days. I think that's better.
That's much better.
2 हफ्ते में पैसा दे दोगे? 2 हफ्ते में क्या? 2 दिन में पैसा दे दोगे? 2
They
दिन
shall
में?
deposit within 2 days
Yes.
and
And we'll-
within
we'll-
48
48 hours.
48 hours.
पहले तो 4 दिन आगे
Anything else, Mr.
Nothing else, man. I'm very grateful to you.
Anything else?
My lord, only one thing. 2 days and 2 days takes us to 26th, and they are closing on 26th. So if it can be
You give it.
1 day, I'll do this. I'll do this. Let it be, my lord.
Shall deposit by tomorrow.
Well, if they put it in 2 days, we'll do it in 1 day.
26
That's the maximum.
Achha, 2 days, 1 day. 2 days, 1 day. But I'm so grateful.
At least
At least I'm getting out of pocket, so I get a little bit time. So I get 2/3 and he gets 1/3
Shall be done within 24
of the time.
hours.
Ani to puro take
Fine.
Oblige.
very good.
Should have a friend like him.
And I am taking advantage. my lord.
No, I'm not. I never take advantage, my lord.
I'm very grateful. man.
Even those biryani bills, my lord, he used to pay. But I have till now, my lord, not said thank you.
Very grateful. Okay. That way.
In the above direction, the present petition. Within 24 hours. Within 24 hours. Can one is also disposed of. I'm disposing of can one. Can one is also. Take up both writ and can together, huh?
May it please, my lord, I am for the petitioner, my lord. My lord, your lordship would remember, my lord, on the earlier occasion, my lord, I had placed the
My lord
case. my lord.
directed us, we are for the KMC led by Mr. Srijan Naik. My lord directed us whether the process, my lord, this is the report came from the authority. And this is to be scheduled on 23rd and 24th for demolition, my lord.
Lord, only if I may get a copy of the report, my lord.
You have an extra copy?
Pardon me, my lord?
Extra copy?
Yes, ma'am.
I am appearing for the state.
My lord, I appear for the respondent number 10.
My lord, kindly take this copy, my lord. That is Xerox.
So I'll dispose it off, madam.
My lord.
Admitted yet, nonsense.
Take down. The petitioner has preferred the present writ petition seeking implementation of the demolition order dated 30th-9/2019 and office memo dated 13/2/2019 qua the premises number 25A Circus Avenue, Park Circus, Benia Hooker, Calcutta, 2017. It is the case of the petitioner that he, along with performer respondent number 15, is the absolute owner of the premises in question.
My lord,
and
my mother, performer respondent number 15, my lord,
15.
she passed away.
She passed away.
Yes, my lord.
15,
It's just me, my lord.
deceased. Deceased. Is the absolute owner of the premises in question. Full stop. Respondent number 7 and 8, being developers, approached the petitioner and performer number 15, since deceased, for development of the said property. Full stop. The proposed development for development of the property. Full stop. Respondent number 7 and 8 were under an obligation to obtain the sanction plan from the respondent municipality. Full stop. However, they commenced construction without the consent of the owners and without obtaining the due sanction plan. Full stop. The petitioner, therefore, raised objections and complaints before the respondent authorities. Full stop. The petitioner, since no action was taken by the respondent authority, the petitioner preferred writ petition number 1957 of 2019. Full stop. While order dated 20th April 2019, this court directed the respondent authorities to conclude the proceedings initiated in terms of section 401 of the KMC Act after affording an opportunity of hearing to the petitioner and the private respondents. Pursuant thereto, the demolition order dated 30th-9/2019 was passed. Since no steps were taken to implement the said demolition order, the petitioner preferred writ petition 7754 of 2020. While order dated 25/11/2020, the single judge of this court disposed of the said writ petition with a direction to the respondent to implement the demolition order within 6 weeks. Full stop. Being dissatisfied with the order dated 24/11, the petitioner preferred FMA number 938 of 2020.
Not me, my lord, the
respondent,
developers.
the private respondent, the developers.
Developers.
The private respondent, the developers preferred FMA number 938 of 2020. Full stop. During the said proceeding, it was noted that the private respondents were also in the process of filing an appeal before the municipal tribunal. Full stop. full stop. Municipal Building Tribunal, full stop. The by order dated 15/12/2020, the Honorable Division Bench of this court disposed of the appeal with a direction to the respondent to the Municipal Building Tribunal to dispose of the said appeal as expeditiously as possible, preferably within 4 weeks from the date of its filing. Accordingly, the private respondent's BT appeal number 2 of 2021 was dismissed for default on 30th/5/2023. Full stop. It is stated by the learned counsel for the petitioner that as of today, there is no appeal which is pending. Full stop. No appeal is pending, comma, but yet the demolition order dated 30th/9/2019 has still not been implemented. Full stop. Learned counsel for the respondent hands over the report, which indicates that the respondent has fixed a program for removing the unauthorized construction on 23rd/9/2025 and 24/9/2025. And notices under section 544 and 546 has been sent out on 19/9/2025. Full stop. Learned counsel for the respondent states that they will abide by the said order and will carry out the necessary demolition action in terms of the law. Full stop. In view of the stand taken by the respondent corporation, nothing survives in the presented petition. The learned counsel for the petitioner has been handed over a copy of the report, and it is expected that the respondent corporation shall carry out with the demolition proceedings as fixed by them in terms of their as fixed by them, as scheduled by them on 23/9/2025 and 24/9/2025. Full stop. With the above direction, the present writ petition is disposed of.
Only one indulgence, Lordship.
Deeply
This is the report in respect of the premises.
Yes, 3rd floor and 4th floor.
Only in respect of the premises. But
Yes.
names are because a lot of other appellants, litigants were there. So in respect of the premises, Lordship, kindly add this. Otherwise, it is in different name. Names are different. In respect of the premises.
In respect of the premises in
Lordship,
question, under question.
It is my duty to point it to other Milord.
Oh, yes, my lord, the cost title is different in the report.
That's why I've said in respect to the premises.
जहाँ वो लिखा हुआ है ना 25A, right? 25A is the
25A, my lord, but the
In
cost
respect of
title
the-
is different.
That's why I've said.
in respect of the premises.
Lordship. And one indulgence, Milord, this is the program. Now, before puja, this program would be implemented, my lord desired, and we are duty bound to comply, my lord, the court's order. Some relaxation, take all endeavor to do it.
Since
Not make it,
2019,
my
my
lord,
lord.
complete.
2019, how much endeavor will you take?
Lord, let them at
Kindly-
least start.
No. Yes, yes. Obviously, we also sincerely want to do it.
You have fixed your program. I have not fixed it, sir. You have fixed the program. Your officers have fixed the program.
Take all endeavor.
Deeply
Only
obliged, my lord.
these words may kindly be.
You will take action as per your own scheduled program.
Deeply obliged.
Grateful, Lord.
Deeply.
Get- No, that is there.
In respect of the premises of question. As scheduled by them on so and so.
Obliged to Lordship.
I'll be back.
I for the petitioner in this matter. Actually, the issue here is.
Okay, help us. I'm for the municipal authorities.
ये first वाला है अच्छा
Waiter, boss. I'm for the municipal authorities. Item number 10 to 19 are almost identical matters. These are regarding recruitment 10 to 19 is.
These are 10 to that connected matter
10 to 19 are almost identical. I just please. I'm for the
you are
municipal.
appearing in
I'm for the municipal authorities. This way. What number responsible?
in all the matters you're there
My lord, issue is that, my lord,
who's for the state
State was appearing in the previous occasion. They sought adjournments. Now, my lord, today, I think they are not appearing. They may come.
Chilo.
There was some advocate.
answering respondent is the municipality right
And subject to their approval is required. I just place in my. But what happened? The issue is that, my lord, we appointed doctors, medical officers in different times in our municipal hospitals without any against the sanction post. Basic things.
without the sanction
We appointed. Then, my lord, the issue cropped up, single division, the issue has been decided by the division bench. Relying on the provisions of law, I just place before lordship, kindly come to find out the 1993 Act, Municipal Act.
the West Bengal Municipal Act
Yes. Also Municipal Act. Section, my lord, 53.
yeah
Can you come to subsection 2? Can you see the subsection 2? It was substituted. And section 2 is now the amended section 2. You got it, man?
subject to the provision of subsection
Now
1
this was substituted. Unamended provision is the next that is given. If you can see that next page, the words if the number of posts to be created. You got it, Mala?
provided that the
Yes. Yeah.
So you kindly come to page 117. Unamended portion of that statute has been clearly
Yes.
reflected in the order of the division bench.
I just
Page 117.
people-
না, আমি ওটা বলছিলাম।
দেখাচ্ছি আমি।
সেটাই বলছি। তোমাকে
The words, if the numbers are supposed to be so created in the year for a municipality is more than 1% of the total number of sanctioned post officers, other employees in existence in the year immediately preceding. My lord, this is 2002, it was substituted. So,
My lord, may I submit one thing, my lord? I'm for the state respondent in this matter, my lord. Entire matters, all matters will be submitted by our learned additional advocate general, Mr. Shane, my lord. My lord, may I submit one thing, my lord? Kindly take it after vacation, any day, my
People are
lord.
suffering since 30
Any day,
years.
my lord. Mr. Shane is now arguing in another court, my lord. Okay, kindly consider, my lord.
we were trying to finish it off before the vacation that's why I've kept it
After vacation, any day, any time, my lord. Kindly excuse me, my lord, for a
But the
moment, my
issue
lord.
is already decided by your lordship also.
He will argue, my
stop
lord.
somebody from arguing na sir
On behalf of the states, must say, Shane will argue, my lord.
Three occasions they were seeking adjournments one after another.
and this is very unfortunate
Sorry, my lord. Excuse
And
me,
just
my lord.
before
last time also you were here
My lord,
and I kept it only for this purpose
as a last chance, my lord. Last time, on municipality took time, my lord. State did
no,
not.
Ms. Bowal was here, but then we made it
Hello.
very clear we want to finish it. Why will I give short dates like
Kindly
this?
consider, my lord.
Division bench, lordship's order.
Mr. Shane will argue in all the
Every
matters.
is operating in the field and their stand is
Sir,
contrary to their
After
own
vacation, any
circulars.
day, my lord.
Their circulars
I
even
can't
Kindly
stop
consider, my
anybody
lord.
from arguing, sir.
A high voltage matter, my lord.
high voltage.
High voltage.
Listen,
They are
you what I
denying pensionary benefits.
Learned counsel for the respondent state submits that the learned who will argue? Advocate General,
Amar Shane.
additional advocate general.
additional
Now,
Advocate
duly,
General, Mr.
Shane, additional advocate general.
হ্যাঁ
Like,
বলছি
he
তো।
was there before the division bench.
Additional Advocate General, Mr.
HON'BLE Sen, my lord.
Amar Sen is in some personal difficulty and prays for a short adjournment. Let this matter be listed after vacation.
My lord, Mr. Shane appeared in the matter before the
বলছেন,
division
জানি তো।
bench. No, bole di. And he accepted the verdict and he directed for compliance and that has been complied. Now he cannot stand in the way.
Whatever
চাইছে
it is,
জোসেফ বলছে
he has to come and argue, sir. All these matters. When do you want? You tell me.
7 November.
After 7th. 7th November. After 7th, he's saying, so give it. Mr. Rai, you tell me, when do you want?
10 and after 7 I'll come back. Yeah.
12th November?
No.
Yes, 12th. আপনি থাক, আপনার থাকাটা দরকার।
12.
12th?
Sorry, my lord. I apologize, my lord. On the open court. It should come to your lordship. I apologize. That I say.
No, for what, Mr. Rai?
I really, my lord. That day.
Lordship, may I beseech?
Not at all.
I
May I beseech one thing, my lord?
That
I didn't expect that from you. That's the only thing which I can say, Mr. Rai.
Lordship, may I beseech?
kindly apologize. Kindly.
Much obliged.
Mr. Rai,
Happy.
I don't take things to my heart at all. It happens.
I know, my
During the course of argument, we have all been through all this.
That I know, but your lordship, this is on my part. I should go to your lordship chamber. But that even I left for Hyderabad.
Yes, you were leaving that. I think probably
My wife is now okay. My lord, kindly, but even I just.
I'm glad she's doing well. These things happen, Mr. Rai.
She scolded me. What? This is against your character.
That I also said.
Yes.
I also said that.
That is my lord. My junior said, she said, sir, how did you do this? Sir? I'm really sorry.
No, you must be stressed out. Some
Kindly apologize.
But only I beseech your lordship, let it be considered as a hard in part. Lordship has hard so many times.
Don't do
I
that.
think they will not going to say anything. Lordship's
No,
order is
objection,
there.
Your lordship, sir.
Don't do that. This is
After
unnecessary.
puja vacation, my lord, if the determination changes, then again, my lord, it has to be started from the very beginning.
I have already got couple of bulky matters heard in part.
Kindly, this is a very small issue. Kindly, these are all same matters, my lord. It is already covered by a lordship's order.
He's talking to Shobdanshu.
Much.
Kindly.
Part heard that.
Hard in part.
Whenever person judgment is my lord.
হ্যাঁ জানি আছে।
Yes.
Item 20, my lord, I am for the petitioner, my lord. Not in fact, my lord, last occasion, my lord was pleased to direct the municipality to file opposition, my lord. Lord, they have filed opposition, my lord. Lordship kindly allow me, lord, 2 weeks time, my lord, for filing, my lord, reply, my lord.
Learned opposition has been taken out.
Nah.
Learned counsel for the petitioner seeks and is granted 2 weeks time to file his reply to the affidavit in opposition filed by the respondent municipality. Let this matter be listed after vacation.
Grateful. My lord, 21 and 22, my lord, similar matter, my lord.
21 voted.
My lord, they have filed opposition and this is my
20. My lord, 20, 21 and 22, I am for the respondent municipality, my lord.
My lord, last occasion they said, my lord, I didn't cooperate with them, my lord. Regarding my signature on pension papers, my lord, I have put my signature on all the pension papers, my lord. I don't know, my lord, whether they have sent the pension paper to the DPPG or not.
My lord, we are sending all the papers. My lord, we are sending all the papers before the DPPG and DADLB on 18th of September 2025 to immediately process their cases, my lord.
Kindly record it, my lord, that they have.
My lord, kindly see, my lord, their instructions, my lord, director of local bodies, my lord, sent to the chairman, Godavarti municipality, that petitioner, in respect of petitioner, name of the employee is mentioned in Milon Rice portal and approval order. Official documents, my lord. My lord, that is their, my lord, that is the instruction from Director of Local Bodies, my lord.
What mismatch is there?
Mismatch?
Have you filed your report?
My lord, Director of Local Bodies, my lord, not filed, my lord. I'm taken instruction from them.
So let them file it then. If there's a mismatch, then
They are saying, my lord, only the mismatch of the spelling of the name, nothing. But DL, your lordship, kindly see my, for a moment, my lord, my reply. Reply to the opposition filed by the municipality, my lord. Everything will be clear.
My lord, if
we are not talking about the municipality. There, it's a directive.
Yes,
You
yes,
are appearing.
they are saying that document, my lord.
Director of Local
My
Bodies.
lord, they are saying that document.
Respond, my lord.
So that has been clarified by the municipality.
Yes, my lord. Yes, yes.
So we'll see after that.
Direct the municipality to clarify and send to the DPPG.
They have already done that. They are saying that they have done
Malad
it.
18 September 2025,
They have done
we
it
have
on 18th of
clarified all these
September.
things, Malad.
Learned counsel for the affidavit in reply filed by the petitioner to the affidavit in opposition of the respondent municipality is taken on record. Learned counsel for the respondent municipality states that the objections raised by the DLB has been replied to wide letter
Malad,
dated,
to the Assistant Director, Government of West Bengal, Director of Pension.
Assistant Director,
Government of West Bengal, Director of Pension, Provident Fund and Group Insurance.
wide letter dated
Letter dated 18 September 2025.
18 September 2025. Full stop. Let this matter be listed on date.
On my lord.
24th November.
24th. Grateful.
Malad, three matters are same, 20, 21 and 22.
This is my reply. Not I reply.
For the state laws.
Similar order in all three
22,
matters.
yes.
Grateful, Malad.
Similar order. Just take it. Reply taken out.
Grateful.
My lord, I am for the petitioner, my lord. This is a pension matter, my lord.
I am for the municipality, my lord. The legal aid certificate, my lord, which is, my lord, already been deposited on 16th of September. That was earlier I submitted, my lord, that was been, my lord, returned to us on due to non submission of the legal aid certificate. Ultimately, my lord, legal aid certificate along with other documents was, my lord, again submitted on 16th of September before the DPH, my lord.
Yes.
My lord, till date, my lord, I don't know whether.
I shall serve a copy upon the, my lord, the document, my lord, which is served, my lord, by personally served upon the, my lord, 16th of September to the, my lord, DLB.
Your report you have filed.
The Assistant Director, Pension and Provident Fund and Group Insurance.
Have you filed your report?
With regard, I shall file, my lord. Your lawyer directed me to submit the document, my lord. I shall file a report, my lord. Kindly give me
File a report. You were
Yes,
supposed to file a report. Direction is already there. You are appearing for director local bodies.
No, I am for the municipality.
Municipality.
Joyanagar Mujibur municipality.
For the state. Your lordship.
Direct counsel for the municipality seeks and is granted.
My lord, if municipality, my lord, submitted the every documents, my lord, then state will, the Director of Pension and Provident Fund will be take steps, my lord. Kindly direct, my lord.
DLB have filed a report.
Respondent number 6 and 7, my lord, the ultimately pension sanctioning authority, my lord.
Learned counsel for the respondent seeks and is respondent municipality seeks and is granted 2 weeks time to file his affidavit in reply, affidavit in opposition, reply if any within 1 week thereafter, list after vacation.
My lord, municipality submitted, my lord, everything. My lord, as per your lordship direction, everything submitted, and director of pension will be take steps to sanction the pension, my lord. But
Who appears
pension,
for the state? Yes. What is the instruction?
We have filed a report in form of affidavit.
That is earlier, my lord. Thereafter, my lord. Thereafter, we submitted the document on 16th of September before the, my lord, the assistant director. of
They are
Public
saying that they have submitted the report.
on 16th of September.
They have, the DLB have filed a report in form of affidavit, your lordship.
Madam, after that, after the objections which you have raised, they have already answered those objections. What has happened after that?
Lordship, I have to take instructions, then I have not got any instructions.
They have to get the instruction.
my lord, I am for the I am for the petitioner, my lord.
I know you're for the petitioner, sir.
My lord.
Let them get the instruction. We'll have it after vacation.
My lord, my learned friend municipality has been submitted, my lord, through a letter dated 16th of September.
What is that dated?
16th of September 2025.
Usko change kar do. Learned counsel for the respondent municipality states that they had answered all the queries raised by the directed local bodies by letter dated
16th of September 2025.
16th of
My
September.
lord, respondent number 7, my
2025.
lord. Director of local bodies, my lord. Director of pension and provident fund.
To the director of pension
Pension
and
and
provident
Provident
fund. Full stop. Learned counsel for the respondent number 7 states that she will take appropriate instructions and prays for a short adjournment. Let this matter be listed. November kar do.
Deeply obliged.
Item number 24, as for the petitioner, my lord, this is the affidavit of service, my lord. Only prayer, there is a development agreement between the petitioner and the private respondent regarding construction. I have invested more than 20 lakhs. There is a threat from the private respondent that they have obtained sanction plan from the KMC. Only prayer whether there is any sanction plan issued by the KMC or not.
Why should this court get into your development agreement?
My lord,
Why should this court get into the development agreement? It's a private dispute between you and the developer.
this is on that point, madam. My only prayer is that whether any sanction plan was issued in the name of the private respondent or not.
Why an RTI? Why should I get into that issue?
I have asked to the private respondent, my lord, on my last.
Why should I get into that issue, sir? Your dispute with your private respondent whether the corporation has issued a sanction plan or not. Why should I get into that?
Let a report be.
No, why should I? No need.
Only a report be.
No, no need for a report. These are private disputes.
I understand, my lord. I'm not
It's
pointing.
a completely private dispute. Nothing to do with the corporation. What do you want? You want a dismissal or you want a withdrawal?
One reply.
No, sir.
Because
Nothing.
the corporation has not replied to my letter.
Sorry, corporation has not replied to your letter. Doesn't mean you'll file a writ petition.
My lord, kindly consider that
No.
I have asked to the KMC that whether any sanction plan or not.
File an RTI. If you want information, file an RTI. This is nothing.
That reply should be come from the
Nothing will come from here. Take down.
My lord, in this matter,
I'll dismiss it.
Mr. NC Bihani and.
Doesn't matter whosoever it is. The petitioner has preferred the present writ petition, being aggrieved by the inaction of the respondent authorities in not taking any steps to stop the alleged unauthorized construction at premises number 116A, Park Street, Beniapukar, Calcutta. Ward number 65, under the KMC jurisdiction, comma, at the instance of private respondents. Full stop.
My lord, one
The
humble-
petitioner entered into a development agreement.
one humble.
Yes.
If your lordship kindly consider direction upon the KMC take necessary steps or as per the.
Nothing. This is a private dispute. Why should I unnecessarily get
Your
it?
lordship kindly consider.
Take down. The petitioner entered into a development agreement dated 30th 8/2022 with the private respondent for development of the said plot, full stop. Pursuant thereto, comma, the petitioner spent substantial amount towards conversion of the property from Thika tenancy in order to enable approval of a building plan by the respondent authorities. Full stop. After completion of the conversion, the petitioner approached the private respondent for implementation of the development agreement, comma, he discovered that the private respondent had, comma, instead, comma, executed another development agreement with a third party in respect of the same property and had also obtained a sanction plan from the respondent authorities, full stop. Being aggrieved, the petitioner submitted a representation dated 26/6/2025 before the respondent authorities, comma, seeking clarification as to whether any sanction plan had in fact been issued in respect of the said premises. Full stop. However, comma, till date, no information has been furnished. Full stop. In the meantime, comma, construction activity has been continuing at the premises, comma, which the petitioner alleges to be unauthorized. Full stop. The grievance of the petitioner is that despite the existence of a valid development agreement between himself and private respondent, the latter executed a new development agreement with a third party. Construction is being carried out in the premises. Full stop. The inaction of the respondent authority in not responding to petitioner's representation has compelled him to approach this court. This court has heard the counsel for the petitioner and has perused the materials on record. It is evident that the dispute essentially arises out of alleged breach of a development agreement executed between the petitioner and the private respondent, comma, followed by execution of another agreement with a third party, full stop. The controversy thus pertains primarily to contractual rights and obligations between private parties, full stop. The grievance, comma, therefore, comma, falls within the realm of private dispute and not within the scope of judicial review under Article 226 of the Constitution of India. The writ petition is not intended to adjudicate private contractual disputes, comma, particularly when the remedies, alternate remedies under civil law are available to the petitioner. In view of the above, comma, this court is not inclined to exercise its writ jurisdiction in the present matter, comma. Accordingly, the writ petition is stands dismissed, comma, leaving it open to the petitioner to seek appropriate reliefs in accordance with law. Information file and RTI. Private disputes between parties. Why should we get into this development agreement? You want enforcement of your development agreement, nothing else.
I am appealing for the municipality.
I beg to appear for the petitioner, my lord. If my lord remembers, my lord, this matter is regarding, my lord, issuance of completion certificate and water connection, my lord. My lord,
You heard it, my lord, for last two occasions.
Yes.
Without complying to 33 and 34 of the
Yes.
building rules, they want water connection. How, let them comply it is certainly they will get water.
my lord, I asked the client for producing, my lord, the application for completion certificate, my lord. My lord, only this receipt has been given by them, my lord, though I'm not sure, my lord, this is the receipt for completion certificate or not, my lord.
He has made a representation.
If it is filed, if they file the application, the petition municipality will consider.
There's a representation he has filed. Decide his representation.
Representation by the lawyer, not by the petitioner.
No, my lord, the
Okay,
petitioner.
you can treat it as a.
They failed to show that they failed to show Form G, my lord.
You are appearing for the municipality. Decide his representation. Finish it off.
They have failed to produce the formality.
Hey, to
under
decide his
40.
representation, if they fail to produce it, it's okay, reject it.
Let them consider and let them cooperate with the formalities.
Let them come with the proper section rule 33 and 34.
34 and 30,
If my-
33 and 34 should be complied with.
If my lord directs that we'll apply again, my lord, in proper format, my lord, for completion certificate. But my lord, the representation also can be considered, my lord.
So you have to apply in proper format. You have not done that.
I will
That
apply
is
it
the
for
law.
phrase, my lord,
Grateful,
again,
That is the
again,
law.
my lord. But kindly,
But
my
what?
lord,
Not
that
pattern of the representation.
let that be also considered,
Representation
my
will
lord.
not do.
Rules is stated in here.
So then we'll leave it. We'll record that, you apply in the proper format. They will
Yes,
consider
yes,
it.
my lord. That much will suffice, my lord.
Let him apply proper format, finish will be considered.
We'll apply a phrase, my lord.
Take down. The petitioner has preferred the present writ petition, being aggrieved by the inaction of the respondent authority in failing to issue the occupancy certificate, right?
And completion certificate.
Completion.
Completion or
Master,
occupancy.
Computer certificate issued by the authority, say after inspection.
What are you asking? Occupancy certificate?
Occupancy certificate, then my lord, water connection, because as per the
Occupancy certificate and not granting the water connection in respect of premises in respect of the petitioner's newly constructed residential accommodation situated at premises number 92, LIC Township, Madhyagram, District North 24 Parganas. Full stop. The petitioner states that by virtue of a conveyance deed dated 27/3/2023, he had become the absolute owner of a piece of land and parcel of Bastu land lying and situated within District 24, North 24 Parganas, PS Madhyagram, Mauza Uday Rajpur, jail number 43, plot number 100, CS and CS, RS Dag number 381, LR Dag number 1034, premises being 92, LIC Township, Madhyagram, District North 24 Parganas. He states that the said property was duly mutated in the name of the petitioner. Full stop. After obtaining the sanction plan, the petitioner constructed the said residential building strictly in accordance with the sanction plan. Full stop. Upon completion of the structure, the petitioner applied for a completion certificate. However, till date, the completion certificate has not been issued. Due to the said non-issuance of the completion certificate, the petitioner has been unable to get water connection to the said premises. Being aggrieved, the petitioner had submitted a representation dated 17/2/2025, but the same has not been responded to. Full stop. Learned counsel for the respondent municipality states that the petitioner has not applied for the completion certificate in the duly mentioned format as
Rule
per
33
the
and 30. Rule 33 and 30.
as per rule
33.
33 of
33 of the
West Bengal Municipal Building Rules.
building rules.
West Bengal
33 and 34 should be complied with.
as per rule 33 and 34 of the West
Building
Bengal municipal building rules. Full stop. He further states that if the petitioner applies under the said rule, his application shall be duly considered. Full stop. The petitioner states that where's the application?
My lord, the application, my lord, I have received, my lord, only this, my lord.
The
No-
petitioner states that yes, petitioner admits that he had not complied with the said rules and had not duly submitted the application form
handwritten CC only, my lord.
as prescribed under the rules. Full stop. He seeks and is granted liberty to apply afresh for the completion certificate in terms of Rule 33 and 34 within a period of 2 weeks from the date of communication of this order, and that the respondent municipality shall consider the said application in accordance with law
Some working days.
after affording an opportunity of hearing to the petitioner or any other stakeholder within 4 weeks,
In the meantime, my lord, puja vacation will intervene.
within 8 weeks thereafter, by way of a speaking order. Full stop. If the petitioner fails to comply with the directions of this court, if the petitioner fails to file the said application within 2 weeks, the 2 weeks, then if you fail to, then they will not consider it.
My lord.
The petitioner is directed to abide by the timeline as prescribed by this court for the respondent to further comply with the directions of this court. Full stop. With the above direction, the present writ petition is disposed of. Affidavit of service is taken on record. Full stop.
I'm grateful.
Vapas.
Grateful.
Yes.
My lord, this matter relates to that granting of mutation in my name. That I am the flat purchaser where I have applied for mutation of the records.
Yes.
In my name, where they have in turn questioned my ownership right.
Yes.
Which otherwise, my lord, the civil till date, the said deed has not been challenged by any of the co-owners. My lord, your lordship has a view, my lord, your lordship on the last occasion has expressed that, my lord, I will try to satisfy your lordship, my lord. Kindly keeps it after the vacation, my lord. I found out few judgments. I am looking for some more, my lord.
At the request of the learned counsel for the petitioner that he is in some personal difficulty, let this matter be listed. The matter is adjourned to give a date in November. Give a date in November. 24th.
24th. Grateful.
24th.
Yes.
Well, at this matter, lordship had considered, but we have given a supplementary affidavit containing some documents and the inspection report of the engineer, my lord.
Yes.
Lordship, in addition to these documents, we have found some new documents also. But there is a debris under which my furnitures, everything, my machineries are lying. My lord, what I humbly pray before your lordship, my lord, but let them not demolish the remaining portion immediately. My lord kindly appreciates. But the portion that was required to be demolished, lordship would kindly turn to the supplementary affidavit. But there is a plan that we have given at page number 43. Kindly comes to page number 43, my lord.
Page number 43 of supplementary.
Lordship.
Yes.
But the portion that is marked red,
Yes.
that is the portion that has been demolished. Some portion had collapsed. The portion that had collapsed is the toilet portion that is shown, my lord, at the right hand side. My lord, adjoining property, my lord, some portions had fallen there. But some people were injured, but immediately they received treatment and they are doing well. This is what my instruction is. Now, my lord, there is no portion left that can fall on anybody, because that is the inner portion of the property. Lordship will kindly come to page number 43 once, and then Lordship will kindly consider the others, my lord.
Yes.
My lord, the green marked portions
are the portions that are now existing. And the engineer has stated that these are portions which can be retained for 3 months. Even more, but
I've
within.
never seen an engineer who can be so
Malad,
precise.
Malad, kindly appreciates if my wordings were perhaps incorrect. Malad, within 3 months, no accidents can happen. Malad, these are portions which would also require demolition, but immediate not required. Now, Malad, kindly see, in these portions which are red marked, portions have been demolished. Malad, it is now at a size of 3 feet, 4 feet, the walls are there. Malad, the corporation wants to demolish that also at the instigation of the private respondents. Malad,
Not at all, not in this.
yes, Malad. Malad, this is what, Malad, if that happens, I can never prove what is my extent of tenancy. Malad, 3 feet, 4 feet walls would not fall on anybody's head. Malad, that would not cause any accident to anybody. Malad, I only want to establish that I had a tenancy over this property, a commission is required to be held. But I have supportive documents in that regard. I have found some more documents. I have given some before your lordship also. But I had cited 2 judgments that this cannot be a ploy of the owners who could not succeed in an eviction suit to get the property demolished to evict the tenant. But only this much security I want from your lordship, my lord. I am praying that before your lordship, my lord. The portion that was hanging, which was not in order, has been demolished. But 3-4 feet walls cannot fall. But the plinth, they want to dig it off. And they are saying that I have a tenancy of 400 square feet. This is not correct. But I would show from the eviction suit that they had filed. I have annexed before your lordship. It was the entire ground floor, excepting one garage.
Yes.
Malad, kindly hears me for a few moments more, Malad. Malad, kindly see, they are stating, I have given a trade license before your lordship. The trade license shows 400 square feet. Now, Malad, kindly see, they had filed an eviction suit.
Yes.
Before the appropriate court kindly turns to that at page number 8 of the supplementary affidavit that we have given to your lordship, Malad. Malad, this is their plaint.
Yes.
Lordship, kindly see all that portion of ground floor of the main building comprising 2 hall. This is paragraph 1. Lordship would kindly see. I am taking your lordship, my lord, to paragraph number page number 10, paragraph number 3C. But I am reading this. That the plaintiff requires the suit property for her own use and occupation and also for the members of her family. The premises in question is a 2-storied building. The defendant is occupying the ground floor. Malad, kindly marks the words.
Yes.
Excepting a garage and pump room under her occupation. The plaintiff lives in the 1st floor. Malad, this is the first indication. I had the entire ground floor excepting 1 garage and pump room. Malad, the second
They are not deciding your.
But no, my lord.
We are only looking
Malad
at.
kindly appreciates one thing. Malad is now deciding whether a building is in a position that would fall on somebody and cause accident. Malad, to that effect, my submission to your lordship, my lord, this cannot be a ploy on the part of the landlords to evict a tenant. Admittedly, this is the second eviction suit that has been dismissed by the court of law. Malad kindly appreciates they had given evidence in the eviction suit stating that excepting the garage and 1 pump room, all other portions are under the occupation of the tenant. But now they are taking a ploy that it is only 400 square feet because I have a trade license. Apart from the 400 square feet, that is the portion from which my trade is being carried on. I have the entire, that is called the portion for storage, the godown, the occupancy of my staff, these are there. But now 5 feet walls cannot fall on anybody. But I want to exercise and endeavor, my lord, so that this can be commissioned in presence of all the parties, the municipal commission also. But thereafter, let it be demolished. But only this much kindly ensures so that there is no, loss to anybody, and whatever is there, but that should be preserved. I should get my tenancy. Dangerous building should fall down, my lord. I'm not standing in the way. But now what they are trying is they want to dig out the plinth of the property. Then I cannot get my property identified by anybody. Kindly appoints a special officer, my lord, on anybody from the corporation authorities, whatever.
Yes.
Yes, Lord, the first, Lord, the answer to my learned friend's query with regard to the collusion with the owners. Lord, I have answered that, Lord, on the last occasion. I should not repeat that. Only the new document by one day he has prepared, Lord, this, Lord, survey report. Kindly once, Lord, looks at page 39. I will, Lord, only, Lord, precise, Lord, with regard to certain portion. Lord, 39, my Lord, would get the purpose of survey. Has your Lordship got it, my Lord?
Yes.
Director of the company wants to pray honorable court so that the demolition process is stops for 3 months period so that machineries, furnitures and other spare parts are removed to a safe place. The building is a narrow road where trucks cannot enter. As such, shifting has to be made by small vans for which shell packets are to be made. Since large quantity of debris are dumped on the articles, numbers of laborers are to be hired for clearance of debris and remove the machinery out of that. At this moment, because of festive and puja, etc., laborers are seldom available. So this is not at all the endeavor of my lord for the purpose of survey. The purpose of survey is not how it can be stopped. Kindly now looks at first anomaly, brief description, point number 5, my lord would get. This is a very old, minimum 150 years historical design. Has your lordship got it? So the learned lord, the surveyor is very clear that this is a very old building, minimum 150 years historical. Kindly, my lord, turns over the page to page 40. Second paragraph after the photographs at the bottom. Age of this type of building is not more than 110 years. That is, the subject building has expired its reasonable life long days back. Now its residual life is continuing. At this stage, any lateral movement of soil under the foundation building shall develop. Settlement cracks, such cracks already developed. The building should be demolished, there is no doubt. But the subject building can be demolished by adopting mechanical force as thicker wall, and the safe weight shall not allow the building to collapse. Due to heavy rains, condition may deteriorate due to growth of plantation. Already access had been formed in roof and walls due to its penetration. On the rear portion already collapsed because of more damage due to the growth of plantation. The main part, though apparently stable, it is no compactness. Any lateral thrust, it should have been not, may endanger the building. As such, this should not be considered as habitable and safe. It is, my lord, a specific conclusion of the surveyor. Now, my lord, kindly turns over what is due to page 42, due to non-maintenance since long the growth of plantation on the wall surface, some portion of the walls from bottom to top develop cracks. No special repairs undertaken in its lifetime. Due to the age, external plaster developed swelling and fell down. Surface becomes barred, and the result of the surface water getting chance to percolate and damaging the walls badly. So, my lord, everything. He is not taking a single burden in his shoulder that, yes, I am taking the burden, this will remain. On the contrary, he is saying the building has not lost his life. And Lord, kindly, my learned senior friend wants to, Lord, fish out evidence from a writ court for the purpose of beneficial of the civil suit, because kindly takes up once his supplementary affidavit, paragraph 7, which I pointed out before your lordship. Now, my lord, he admitted in his writ petition that there are 2 tenancies. In respect of one person, he has shown. Now, what he is saying, Lord, the condition of the building, Lord, I am not troubling. Paragraph 7, 1, 2, 3, 5 line from the top, my lord. As the main intention of the private respondent. Has your lordship got it, Lord?
Yes.
private respondent herein is to anyhow evict the respondent or to give a portion of 400 square feet to the petitioner only on the basis of the trade license, which is not permissible in the eye of law. In reality, the occupation of the writ petitioner is the subject premises is 2472 square feet, and the trade license of the petitioner shows only an area of workshop measuring 400 square. But this is something which needs evidence, my lord, to be adduced. That's why he has gone before the civil court. But in my respect to submission, my lord, this cannot be done, my lord. Grateful.
But I have already submitted, and the my lord, the engineer's report has been has already been shown to my lord. Your lordship, another paragraph is there. Your lordship, kindly see just the at page 40 after my lord, the photograph. All arts are brick made with surki mortar, fail. Small rooms, a few small rooms are there, which renovated at later stage. Roots of the plantations penetrated inside the roofs and walls. As a result, the main structure severely damaged by seepage. As because the thickness is 30, it will not collapse unless it is dragged down by mechanical force. Now, my lord, according to in the opinion of the corporation's engineer after the accident took place, my lord, that the entire building has to be pulled down. The demolition has started. My lord, at this juncture, my learned friend's client has approached before my lord. Now, your lordship will kindly consider if it is allowed to stand. But any day, any accident can take place. And my lord knows in all such cases, corporation is held responsible. But who will take the responsibility? According to the corporation, it has to be pulled down immediately. And my lord, I don't think there can be any, my lord, impediment on the part of the writ petitioner to take away his machineries, as admittedly, my lord, it is only within 400 square feet, as has been admitted by the supplementary affidavit also. Your lordship will kindly consider and pass appropriate.
Appearing for the response number 8, there are the sum of the the articles are the lying in the ground floor of the the building. That can be shifted. I have been objected by the municipality to shift all the articles which has been kept in the ground floor of this building.
Shifted?
Shifted. Otherwise, I cannot shift the all articles which has been kept to the.
Who are you?
Response number 8. I am also the landlord. My premises is 120, 121.
Practically, my lord, one premises, my lord, it has been numbered.
No, yes, because
two
because
numbers
of
are there,
partition held in
one
60s.
integrated petition building.
That is my premises number 121 by L by 4C. This is my premises.
Move appropriate application before the municipality.
As you lost.
But I may be permitted to add one thing, my lord.
Yes.
My lord, in paragraph number 7 of the supplementary affidavit,
Yes.
my lord, the meaning is otherwise. My lord, they wanted to show before your lordship, my lord, that 400 square feet, it is the trade license. But we admit 400 square feet is the trade license. But the extent of tenancy, that goes particularly from the plaint, as well as the evidence given by Ratna Bosch, one of the owners. Kindly see page number 30 and 31. My lord, it is her version. My lord, paragraph 6 at page 32. Lordship would kindly see.
Yes.
My lord, she says, in the evidence before the trial, the eviction court, I say we plaintiffs require this property for our own use and occupation, and also for the members of our family. The premises in question is a two-storied building. The defendant is occupying the ground floor, excepting a garage and pump room under our occupation. This is our tenancy, my lord. Kindly protects it.
This Bani Basu is not a part of this writ.
Yes, absolutely. A party.
The petitioner
Ratna Bosch
has preferred the present writ petition, seeking a direction upon the respondent corporation to immediately cease and desist from carrying out any demolition work beyond the declared unsafe portion of the building situated at premises number 121/4K
But
and
I've
121.
forgotten one thing, my lord. if Lordship would kindly permit me. But there is a plan,
Yes,
corporation stamped plan of
very good.
1961.
We are not getting into your plans. And क्या लिखा है? 4L/1 Maniktala Main Road, Calcutta. And further to quash memo number B/87/Roman 3/2526 dated 13/8/2025 to the extent it affects the portion occupied by the petitioner in the said premises. Full stop. The case of the petitioner is that he has been a tenant on the ground floor of the aforesaid premises for the past several decades. Full stop. The premises were subsequently partitioned by the erstwhile owners and had been assigned two separate numbers as mentioned above. Full stop. However, the ground floor continued to remain in the possession of the petitioner without any physical partition. Full stop. However, on the ground floor, however, the petitioner used to pay the rental to the respondent, but disputes arose and the respondent stopped accepting the rent, and the petitioner has been depositing the rent before the rent controller. Full stop. On 2/8/2025, the portion of the two-storied structure at 121/4K collapsed. Thereafter, on 13/8/2025, the respondent corporation issued the impugned memo number B/85/3/2025 under section 412(2) of the Calcutta Municipal Corporation Act, directing vacation of the said premises. Full stop. It is the contention of the petitioner that the notice was issued without conducting any proper inspection and without the petitioner being afforded an opportunity of hearing, being an occupier, he should have been granted an opportunity of hearing. The petitioner also alleges that the respondent municipality is hand in glove with the landlords, and the impugned order has been passed to evict the petitioner. The petitioner
Section 411 subsection 2, the emergency power.
Yes, but the notice is 412. The petitioner has further contended that he had instituted a title suit.
Page 35.
Title suit number 198 of 2025 before the learned civil judge, Senior Division Sialda, against the principal defendants, wherein the respondent corporation has also been averred as a party respondent, performer party respondent. Full stop. By order dated 29/8/2025, the trial court was pleased to restrain the principal defendants from evicting the petitioner from the said premises without following the due process of law till 24/9/2025. It is the contention of the learned counsel for the petitioner that he has been the tenant in the subject premises for several decades, and his right to alternate accommodation cannot be ignored by the respondent by removing the petitioner from the said premises. Full stop. it is further alleged by the petitioner that the said action of the respondent corporation in proceeding with the demolition without granting an opportunity of hearing to the petitioner is in contravention of section 412 of the Calcutta Municipal Corporation Act. Full stop. Learned counsel. Anything else which you want to say?
But the two judgments that has.
Learned counsel for the petitioner has relied on two judgments of this court to state that the petitioner, since he is a tenant, cannot be removed from the subject premises by following a process wherein the petitioner has not been granted an opportunity of hearing by the respondent corporation to evict the petitioner from the said premises. Is that anything else in that judgment? What else is there in that judgment?
But it cannot be the corporation and the landlord joining hands.
It is further pointed out that the petitioner, by the petitioner, that the landlord and the corporation cannot join hands in passing of an order of demolition, wherein it will affect the rights of the petitioner to be evicted from the said property. That's it. Full stop. Learned counsel for the respondent corporation submits that the building under consideration is in a dilapidated and dangerous condition. Full stop. He has further drawn the attention of this court to a newspaper article of Times of India dated, what is the date of this? 2nd August 2025, wherein a news article has surfaced where 2 kids among 5 people have been hurt due to the collapse of the present building under question. Full stop. It is further stated that the portion of the building had it is further stated that the portion of a building had already collapsed and the remaining portion is liable to fall at any point of time. Full stop. He further submits that the petitioner is not in residential occupation of the premises as the same has become uninhabitable. However, he continues to use a part of the structure as a godown. Full stop. Learned counsel for the respondent contends that merely to protect the tenancy rights claimed by the petitioner, the threat to life and property of public at large cannot be put at risk. Full stop. It is therefore, urged that the respondent is justified in carrying out the demolition activity by invoking the emergent powers as vested under section 411 subsection 4 of the Calcutta Municipal Corporation Act 1980. Full stop. Learned counsel for the private respondent 5, 6 and 7 contends that the civil dispute is pending adjudication before the learned civil court. He states that the petitioner had filed a writ petition on what was the date? He had filed the writ petition. He had filed the civil suit on
Civil suit, my lord, on 30th August 2025.
30th August 2025 before the civil court and had made the respondent corporation performer. It is 29th August 2025 and had made the respondent corporation performer party before the civil court, but nowhere in the civil suit has he mentioned about the tragic incident which had taken place on 2nd of August 2025, wherein the portion of the building had collapsed, causing grievous hurt to 5 people, and among them 2 children. Full stop. He further points out that the petitioner had withheld all this fact only to save his tenancy rights, and that the private respondent had nothing to do with the passing of the impugned demolition order, and the same has been passed by the respondent corporation, invoking its emergent provision under section 411(4) of the KMC Act in view of the circumstances which had taken place wherein the part of the building had collapsed. Full stop. This court has heard the submissions.
Survey report also, my lord, my
The
submission.
learned counsel for the private respondent has also drawn attention of this court to the supplementary affidavit filed by the petitioner, wherein a report has been placed by a private what is the engineer? By a private engineer regarding the stability of the building. The report dated 18/9/2025 reads that the purpose of survey, ये copy करो यहाँ से, page 39, so and so, was this, and it further reads that the building is absolutely unsafe for habitation and can collapse anytime. Though in the final opinion, the engineer has pointed out that the main part of the ground floor are not in safe condition, and though from the opinion of the engineer, it seems that he was only concerned with the shifting of the articles lying in the building, and had stated that though the building is dangerous and it can fall anytime and is more than 150 years old, the petitioner can take out his articles in a period of 2 months after puja. Full stop. Though this court is in agreement with though this court is surprised that if the engineer himself states that the building is dangerous and is completely uninhabitable and is unsafe, then
number 8 can
the fact that it can sustain for 3 months, in the opinion of this court, is an aberration and cannot be relied upon. Full stop. Uske baad kar lo. This court has heard the submission advanced by the counsel for the respective parties and has produced the materials on record. Section 412 of the Calcutta Municipal Corporation Act deals with the power of the municipal corporation to order the vacation of the building in certain circumstances. The said provision reads as under. The purport of section 412 of the Calcutta Municipal Corporation Act is to vest in the municipal commissioner emergent powers to secure the immediate vacation of premises which, in his opinion, are in a dangerous condition. comma, lack sufficient means of ingress and ingress in case of fire, or are under occupation in contravention of law, full stop. The provision intended to safeguard and life and property in situations of imminent peril and authorizes even forcible removal through notice, through police assistance in case of non-compliance of the commissioner's directive, full stop. Although ordinarily the principles of natural justice requires that the affected parties be afforded an opportunity of hearing, comma, in cases of emergency, comma, such as where a portion of the structure has already collapsed or where there is imminent danger to human life, comma, the requirement of prior hearing must yield to the necessity of imminent necessity of prevention, necessity of preventive action which can endanger human life, full stop. In such circumstances, comma, the duty of the commissioner is to act with promptitude to avert disaster, comma, while the safeguard of reinstatement remains available once the unsafe or unlawful condition is remedied, full stop. In the present case, it is not in dispute and it is admitted that the present building had become unsafe and the impugned order has been passed by the respondent authority, keeping in mind the report of the engineer of the corporation as well as the report of the petitioner, the report of the petitioner, the report of the architect on which the petitioner has also relied, also declares the present building to be unsafe and in a dangerous condition, since it is a building which is more than 150 years old, full stop. In the present case, comma, a part of the building has already collapsed and the remaining portion is in imminent danger of falling, comma, it was incumbent upon the respondent corporation to take immediate steps to safeguard human life, full stop. The action has been taken invoking section 412(2) of the KMC Act and directing the petitioner to vacate the premises so as to facilitate the demolition, and the said action cannot be faulted, full stop. The petitioner has already instituted a title suit to establish his tenancy rights, comma, which he is at liberty to pursue before the competent forum. The judgments relied upon by the petitioner is not applicable in the facts of the present case, since the allegation that the private respondent in connivance with the respondent corporation has resorted to means by which the petitioner can be evicted is not evident from the facts of the present case, and the demolition order as well as the vacation order has been passed keeping in mind the imminent danger faced by the public at large, full stop. Anything else?
Well, a respondent 8 can leave is granted to make a fresh application.
Whatever you have to do, you do it.
Remove the article.
It is further observed that that a dilapidated and an unsafe structure cannot be permitted to stand merely for the protection of tenancy rights, full stop. Accordingly, the present
we may be permitted to take out the machinery which are there, my lord. Those are expensive things.
He can always take
remove an application. Learned counsel for the petitioner states that he shall be at liberty.
If we do that, my lord,
I'll pass an order. You remove. Learned counsel for the petitioner states that he shall be at liberty to remove the articles which are lying in his godown within a period, full stop. He states that he will be moving an appropriate application before the respondent municipality within 3 days, from the date of passing of this order, full stop. The respondent municipality shall allow the petitioner to remove his valuable articles from the said godown within 3 days thereafter.
Well, respond.
thing you'll appreciate, the office of the corporation will also go on vacation within this.
So I'll make it one day. When is it? फिर उसको वो मत करो, application हटा दो. Learned counsel for the petitioner shall be at liberty to remove the said the articles as claimed by him from his godown, and the respondent municipality shall allow him to remove the said articles on, give a date.
Well, respond number 8.
My lord, in 24 hours, the day they will apply, my lord, the corporation will give the permission. They will talk
Shall
to
move
the
an
executive.
application within 1 day, and the respondent municipality shall grant them
Kindly write.
the liberty to remove take out the goods within 24 hours.
It will be within the pujas.
It won't be. When is the corporation closing down?
The corporation will be from
Saturday
26
they go.
itself, I understand.
26. Next week only. It will be next week.
This week, this week, Friday.
So we'll make it 1 day. That's the only thing which I can do for you. You move an application, they will allow it within 24
But
hours.
within 1 day, I cannot take everything, Millard. That is the main difficulty. These are machineries, Millard. It was an
All right. Learned counsel for the petitioner will move an appropriate application for removal of the articles from the godown. The respondent corporation shall decide the said application in accordance with law.
Well, respond number 8, my lord, kindly allow me to, my lord, to remove the article.
Accordingly, the present writ petition is dismissed. The petitioner shall be at liberty to pursue his tenancy claims before the appropriate.
Milord, the newspaper article, Milord, is 3rd of August, not Milord 2nd. Milord, I have.
3rd of August, newspaper article 3rd of August.
Well, respond number 8, my lord, means kindly leave granted to, my lord, remove the articles. Kindly
Respondent number petitioner का कर दो. Respondent number 8 is also at liberty to move appropriate applications before the respondent corporation to remove his articles within a period of 1 week. The corporation shall decide the same in accordance with law.
Grateful. Extremely.
Yes.
My lord. My lord, this is a case where
But I'm appearing for the respondents, Lord.
my lord, a demolition order is being passed, my lord.
Yes.
My lord, the issue is that, my lord, I am the only son of my mother. The land recorded in the name of my mother. My mother died presently. I am aged about 74 years. My lord, when I raised construction after my retirement, my lord, I raised the construction up to the level of first slab. My lord, a stay order was issued by the municipality, and on the basis of that, no further construction was carried. Ultimately, it culminated into an order by the statutory authority, whereby directed to demolish the same. That was challenged in an appeal, my lord. In appeal also, the same was dismissed. Thereafter, while my second appeal was pending before the Lieutenant Governor, my lord, the authorities pursued further to give effect to the demolition order. I filed a writ petition before this honorable court, and this honorable court gave me protection for a limited period. And my lord, subsequently, now the second appeal was also dismissed. My lord, only two grounds, my lord, which I want to urge before my lords. My lord, so far as my lord, this island is concerned, my lord, there is a building bylaws which was framed in the year 1999, whereby there says that, my lord, certain of the offences are compoundable and some are not compoundable. But the regulation, which is framed under Article 240, my lord, that regulation says, my lord, all are compoundable. So, my lord, that issue was taken up by our High Court, my lord, and my man is standing in the court, my lord, with that judgment of 2001, whereby the High Court said, and my lord, it's a second principle of law that regulation will prevail over bylaws, my lord. Now, my lord, my only contention is that all the authorities did not consider this aspect, that instead of demolition, compensation could have been accorded, my lord. This is, and my writ petition is pending before the
See, Mr. Binu Kumar, the problem is that you never had a sanction plan.
Yes, ma'am.
After conducting the, after carrying out the construction at the time of demolition notice, you sought for a sanction plan.
Yes, ma'am. That has been written by.
4 rounds of litigation, literally, you have been everywhere, all over the place.
My lord.
Without a sanction plan, what do you expect?
My lord, if it comments to my lord, because my lord, if it comments to my lord, the law is my lord, because my lord, demolition is
What
not
is the
the
law
only
that
mode,
you
my
can construct without a sanction plan, and it should be
My lord,
condoned?
there are, my lord, there are some things, my lord, which I can, my lord, argue before the writ court, my lord. If my lord, if for a limited period, my lord, because my lord, the compensation, my lord, the law clearly says, my lord, the statute that compensation can be. Demolition is not the only mode, my lord. I am today arguing only on the mode.
The entire structure in question is unauthorized in question because he is not having any sanction.
No construction has been made. Only, my lord, in para
That's
10,
why
I
notice has been
stated, my
issued.
lord.
But I could have understood if any due process have not been followed. The authorities have followed all the process. And he himself has approached before the High Court. He said that the second appeal is pending. I should not be disturbed. The second appeal has been come. Thereafter, the authorities issued an execution order saying that Honorable Lieutenant Governor, being a second appellate authority, has dismissed your appeal. Then they preferred a writ petition, my lord, challenging that execution order.
My lord, my only submission is if it comments to my lord, because my lord, demolition is not only the mode. I am not challenging the part of the order where they said that yes, demolition, this is unauthorized, whatever may be. But I say, my lord, when there are two modes, they could have, they are state authority, my lord, they could have considered this aspect and pass any order. Demolition doesn't automatically follow, my lord.
Mr. Binu Kumar, if you don't have a sanction, what order do you expect the authority to pass?
My lord, my writ petition is pending. I leave it to this court, but my lord, kindly consider this aspect. Only 4 days left, my lord.
Consider what factor? You give me a room to consider any factor, I'll consider it. Give me a
No, my lord,
ground.
at this junction,
What
my lord,
ground are you giving me?
My lord.
What ground are you giving me? You're not giving me any ground to consider any of your factors.
My lord,
What do I
my lord,
consider?
what has been fallen from my lord, I oblige, my lord. But the only, my lord, today we are at the point when my writ petition was filed. I am seeking for an interim order. And my limited argument is that, my lord, they have to consider both the aspects which was not
An
considered.
interim order has to be granted based on some document. Not because you have filed a writ petition, interim order has to be granted.
No, my lord will find that after the stay order was issued, because they consistently say that even thereafter, we have continued with the construction, but we have not, my lord, because in para 10 and in the building is still standing, my lord. Only first floor slab was put. No construction, nobody is residing. It has not been covered. Only this plinth beam, column and slab is. So, and my lord, there is a procedure where post facto approval can also be given, my lord. My lord, may kindly consider this. This is my submission, my lord. Because my only consideration is when law says that there are two aspects to be considered, you have considered only one aspect. You could have considered the second aspect also, whether compensation can be.
Compensation? What are you saying?
My lord,
What are you saying? Compensation?
my lord, because
What
this says,
compensation?
my lord, compoundable offense, my lord. 1 point, whatever
Compounding.
the compounding, my lord.
Not in the
Compounding.
regulation. There are two modes, my lord. One is compoundable.
Compounding can only be for minor deviation, not for
Yes,
the.
yes.
No,
That
no,
should
no,
be.
my lord. My lord, that
Minor
is the
deviation
judgment
is
if my lord
compoundable.
sees. Because bylaw says, my lord, only minor deviation. But the regulation under section 168F, it categorically say, and the issue was cropped up before the division bench of this honorable court. My lord, that judgment is there, my lord. If my lord, it comments to my lord, my man will hand over the judgment, my lord.
But after that judgment, several orders were passed
No,
by
no,
the
no, no, no. There is no judgment which distinguishes this judgment. And the regulation says
Where
so.
is the judgment? Which judgment?
My lord, that KM Suresh versus Lieutenant Governor, my lord. Para 15 to para 20, my lord.
अरे दो ना यार.
Paragraph 15 to paragraph 20, my lord. And my lord, the first word of the section 168 says, if the erection or re-erection of a building is begun or continued without sanction. So, my lord, it apply even the cases where there is no sanction, my lord. My lord, for a limited period, my lord, I pray, my lord, it may be, my lord. Otherwise, tomorrow, my lord, that was the urgency. Because tomorrow they are starting, they are, as per the notice, they will start. In my CAN application, that notice is included, my lord.
Yes, Mr. Rakesh Kumar.
My lord, this K and Suresh matter, my lord, that is a deviation to the existing building plan, my lord. So far as that fact is not applicable to the present case, because as per the regulation, there are two aspects. One is compoundable, non-compoundable. If minor deviation, that is compoundable. And it is an entire, the structure in question is without unauthorized building plan, my lord. Because the landed property is not recorded in the name of the petitioner hearing. Lord, I oppose the interim prior, my lord, because he got all the opportunities to defend himself and he has failed to produce any justifiable grounds that can be stayed, my lord. This is my respectful submission.
My lord, I am representing the Revenue Department, respond number 4.
Yes, what do you have to say?
My lord, there is no prayer against me, my lord.
You have nothing to do.
My lord. My appearance may be recorded.
The petitioner has preferred the present writ petition. Roman 1, assailing Roman 1, the impugned demolition order dated 17/10/2023 passed by respond number 3, whereby directions were issued to demolish the alleged unauthorized construction raised by the petitioner over survey number 58 and 59, measuring an area of 109 square meters and 1176 square meters, situated at Jangli Ghat village, ward number 13, Sri Vijayapuram, without obtaining a sanctioned building plan. Roman 2, the appellate order dated 3/10/2024, bearing number 1139, passed by the respond number 2, the appellate authority, whereby the passed by the appellate authority, whereby the order of the respond number 3 was mechanically affirmed. Roman 3, the order dated 14/8/2025, passed by respond number 1, whereby the revision application filed by the petitioner was also dismissed. Full stop. Learned counsel for the petitioner, Mr. Binu Kumar, submits that the notice, you are challenging the notice also, right?
My lord.
Notice dated 16/9/2025 passed by the secretary, SVPMC, सब capital होगा, secretary, SVPMC, directing the executive engineer to carry out the demolition on 23/9/2025. Full stop. It is the case of the petitioner that his deceased mother was the recorded owner of land as mentioned above. Full stop. Upon her demise, the said property devolved upon the petitioner by way of inheritance, the petitioner, wide application dated 1/6/2023, applied for mutation of the said property. Full stop. The same is still pending before the respondent authority. Full stop. It is submitted that there existed an RCC building and a semi-RCC structure on the said land. Full stop. in the early part of 2023, the petitioner commenced construction of a new RCC building and raised construction up to the level of casting of the first floor slab. Full stop. Respond number 5, issued notice, issued order number 3279 dated 15/6/2023, directing the petitioner to stop the unauthorized construction and not to proceed any further without obtaining a sanction plan. Full stop. Thereafter, following a hearing, order dated 2/8/2023 and 13/9/2023 were passed, directing for demolition of the illegal structure, unauthorized structure. Full stop. Ultimately, while order dated 17/10/2023, a final demolition order was issued in respect of the said premises. Further, a provisional sealing order dated 18/1/2024 was also issued. Full stop. On 19/2/2024, the petitioner submitted a building plan for sanction. Full stop. However, the same was returned by order dated 11/10/2024 on the ground that the land has yet not been mutated in the name of the petitioner, and the unauthorized construction which has been carried out by the petitioner on the above said premises is without a sanction plan. Full stop. Consequently, the demolition proceedings were initiated against the petitioner. The petitioner challenged the demolition order dated 17/10/2023 by filing an appeal. Full stop. By order dated, however, by order dated 3/10/2024, the said appeal was dismissed. Thereafter, by order dated 10/10/2024, the respondent directed demolition of the unauthorized structure by 25/10/2024, full stop. On 18/10/2024, the petitioner deposited an amount of 3,37,252 towards the estimated, the petitioner was asked to deposit an amount of 3 lakhs so and so towards the cost of demolition. The petitioner agreed by the same. The petitioner referred a revision application challenging the order dated 3/10/2024 passed by the appellate authority. Since the respondent authorities were proceeding with the demolition, the petitioner filed WPA 529 of 2024 before the Port Blair bench of this honorable court. Full stop. The said petition was disposed of by order dated 24/3/2025 with an observation that the matter was under consideration before the respondent authority. जहाँ वो लिखा ना रेड पिटिशन फाइलर against the rejection order, वो कर देना वहाँ against, हाँ वहाँ उससे पहले लिख देना against the rejection order for the building plan. Rejection order for the building plan. Thereafter, by order dated 16/9/2025, the respondent authority directed the implementation of the demolition order dated 23/9/2025. Implementation of the order on 23/9/2025. implementation of the demolition order on 23/9/2025. In view of the same, the petitioner has mentioned the presented petition for hearing. Full stop. Learned counsel for the petitioner states that his mutation application is still pending consideration before the respondent authority. He further contends that he has constructed the building strictly in accordance with the applicable building norms, and there is no violation of building rules. He further contends that the said building can be regularized and there is nothing and is within the compoundable limits, full stop. He further states that he further relies on the judgment of this court in K. Suresh versus Lieutenant Governor 2009-3 WBLR 166 to impress upon the court that even if there is an illegal and unauthorized construction without a sanction plan, the same can be retained by the corporation by charging a compensation fees. Full stop. He states that the building bylaws 1999 and the Andaman and Nicobar Municipal Regulation 1999 empowers the municipal authority to accord post facto sanction in respect of constructions which have already been undertaken. Full stop. Learned counsel for the respondent submits that petitioner has carried out unauthorized construction without obtaining the building plan from the respondent. Full stop. There is no provision for compounding the unauthorized construction raised without a sanctioned building plan. The petitioner was given an opportunity of hearing at every stage before passing of the demolition order. Full stop. He further states that the respondent authority can only regularize minor deviations and cannot compound a complete illegal unauthorized construction without any sanction plan. Full stop. He has उसके बाद this court has heard the argument advanced by the counsel for the parties and has perused the materials on record. A perusal of the impugned demolition order dated 17/10/2023 reveals that the petitioner was carrying on unauthorized construction over the subject land without obtaining any sanctioned building plan. Full stop. Initially, a work stop notice was issued dated 15/6/2023, followed by an opportunity of hearing granted to the petitioner on 21/6/2023. Full stop. Thereafter, a notice was issued on 2/8/2023 under section 168A of the Andaman and Nicobar Island Municipal Regulation 1994. Full stop. A provisional demolition order was passed on 13/9/2023. Full stop. Since the petitioner failed to remove the unauthorized construction, the respondent municipality, in exercise of powers under section 168 or 168A of the aforesaid regulation, read with the bylaws, directed for demolition of the unauthorized structure. Full stop. Consequently, a sealing order was also issued. Full stop. The statutory appeal preferred by the petitioner was dismissed on 3/10/2024. Full stop. The revision application was also rejected by an order dated 14/8/2025. full stop. Finally, while order dated 16/9/2025, the demolition has been scheduled for 23/9/2025. Full stop. It is evident that the petitioner had undertaken the construction without any sanction plan. Full stop. Despite issuance of multiple notices, the unauthorized structure remained, full stop. The impugned orders were passed after affording an opportunity of hearing to the petitioner at every stage, full stop. The petitioner does not dispute that the fact that the unauthorized construction has been raised without any sanction plan, full stop. The judgment relied upon the petitioner is not applicable to the facts of the present case, full stop. The Honorable Supreme Court has categorically, in plethora of judgments, has observed that any unauthorized construction shall be dealt with severely, full stop. Since the petitioner has raised the unauthorized construction without any sanction plan, there is no question of compounding of the said structure. In the present case, the petitioner has not even moved an application for compounding, which could be considered by the respondent corporation, full stop. In view of the above, this court finds no illegality, arbitrariness, or perversity in the impugned order, full stop. The petitioner has failed to demonstrate any malified or procedural impropriety in the decision-making process, full stop. While exercising jurisdiction under Article 226 of the Constitution of India, this court is concerned with the decision-making process and not with the merit of the decision itself, full stop. Since no infirmity is found in the present impugned order, this court is not inclined to exercise its discretionary jurisdiction, full stop. The present writ petition is dismissed.
Obliged. But can is also required to be dismissed, my lord.
Can be dismissed, along with the can.
Obliged.
Obliged.
Am I permitted to leave, my lord?
Plethora of judgments has observed. Has
Lord.
observed that has to severally.
But am I permitted to leave, my lord?
Yes.
Obliged.
If you want वो एक judgment अभी इसमें हर में quote कर रहे हैं ना उसको डाल दो, उसको डाल दो. Justice महादेवन का एक judgment है, उसको उसमें डाल दो.
28 time for the petitioner.
Yes.
Lord, on the previous occasion, my lord, your lordship was suggested that we go before the tribunal and pray for a leave. My lord, I went before a tribunal on Friday, my lord. The leave has been granted. It is getting filed as you speak.
Learned counsel for the petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn.
Lordship, I am for the
My lord, petitioner is the owner of the premises and record of right has been annexed. And all of a sudden, in order to stop the petitioner, posted a board that is annexure P3, P16. Annexure P3, page 16.
Yes.
The land belongs to Garden Ridge Water Works, GRWW, KMC Water Supply Department.
No.
My lord, that KMC cannot acquire any land. I have a judgment on this. And before that, my lord, I want to draw attention, Annexure P2, page 50, just before that page. Under Right to Information Act, I inquire about that say poster. My lord, my holding is 234/580. An information petition, it is not acquired. Above moja are not affected in any LA proceeding as per overlapping register. So, my lord, my land is not in the acquisition process. In spite of that, KMC authority acquire or posted that. My lord, they can acquire any land that is under section 352(2) of the KMC Act. And that has been ultra vires by the Honorable Supreme Court.
এই প্যারাগ্রাফটা পুরোটাই লাগবে।
That is also KMC matter. Well, 38 and 39.
না 38 এর উপরে পোরশনটা।
Acquisition should have been facilitated by approaching the state under section 537 of the said act. Entire action concerned the acquisition of property by invoking section 352A of the said act as per illegal, invalid, and clear.
Sir, which is this way, you don't give a copy to the court.
না কপিটা দিয়ে দাও, কপিটা দিয়ে দিও। আমি
How many copies you have?
Well, kindly take
কপি
this
এই
copy.
কপিটা দিয়ে দাও।
Take this copy.
Take this copy. Are you doing me a favor?
Well,
You have come to argue a matter.
As annex only one, that is the whole thing. Well,
Why did you come with one? You come tomorrow then,
tomorrow.
not today.
Only I'm submitting, well, I may have to take instruction because he's saying that he is the owner of the property and the corporation has put up a hoarding, well, the land belongs to the corporation or something like that. Well, I have no instruction. What my land is 352 or something like that. I will not be on
Wednesday?
that. On
You
that.
come Wednesday?
No.
I may have to take, if you also
You
takes it
take
up.
instruction. Take instruction. Wednesday.
Wednesday. Mala, deeply.
আপনি কি সাইটেশনটা দিচ্ছেন একটু চেক দেখে
দরকার নেই
ও পাকা লোক আছে
না পাকা লোক থাকতে পারে
ওটা তো আমি
আমরা তো পাকা নই এমসি ভার্সেস তোমার সাক্ষী নেই
But I beg to appear for the private.
State respondent.
about the municipality lordship
কাগজ।
So what's the purpose of appearing this matter?
Wow. Keeps it after the vacation, blood. Keeps it after the vacation. I'll be in some difficulty, blood. Keeps it after the vacation. Not today. লিখে ছুটির পরে থাক না।
Mr. Chakravarti is also asking for after vacation.
The petitioner is also not there, blood. Tomorrow, day after, but I am. Keep it after the vacation, blood. Let's come back.
As a request of the parties that this matter be listed after vacation.
24th November.
Who's appearing for the respondent municipality?
lordship
Saying, where is the reply?
lordship the report is ready let me come back with an affidavit lordship
Lord, my lord may extend the time to
Learned
file
counsel
that.
for the respondent municipality, Ms. Sen seeks and is granted further 1 week time. You'll file it within this week.
yes lordship
1 week time to file her report, exception to the same, if any, within 1 week after.
Lordship, kindly make it 1 week after vacation if it is possible. Lordship.
Why, if it's there, file it. Seeks and is granted further time after 1 week after vacation. Reply to the same if any after 1 week.
Lord, time also to ask to file the affidavit, Lord, against the petition.
Yes, who's for respond number 7? You are?
I am for the response.
Yes, you are also seeking more time.
1 week after vacation, Lord, and let it come back on 24th. By that time, it will
Learned
be
counsel for the respond number 7 seeks and is granted 1 week after vacation to file his affidavit in opposition. Reply to the same if any within 2 weeks thereafter. List 4 weeks after vacation.
4 weeks after the vacation. 4 weeks, Lord, will take us to
28th.
24th of November, I believe, because we are opening on 27th of October.
24th.
Grateful to Lord.
Grateful, Lordship.
I pay for the petitioner and also this is the matter in which the bank is aggrieved by the steps taken by KMC. The property which is mortgaged to the bank, while the bank was about to take physical possession of the property, it was found that KMC has put their padlock on account of tax outstanding of rupees 64 lakh or an odd amount. That was, my lord, the bank is ready and willing to pay the amount, my lord. However, the difficulty is that, my lord, since the property is under lock and key, I am unable to give inspection to the intending purchaser, for which the property cannot be sold, my lord. On the last occasion when the matter was taken up, my learned senior friends insisted upon furnishing up a undertaking that bank will pay the dues. Bank is ready and willing to submit the undertaking, my lord, and even to pay of the dues. But initially, at least an occasion, it can be the padlock can be opened and the inspection to the intending purchaser can be given, my lord, because otherwise it's very difficult to sell the property, my lord. The bank's outstanding is more than 50 crores.
Most
15
bank
crores.
properties goes as is where is basis.
Lordship, but however, it will not fetch the
Whatever
actual
it is,
value of
madam,
the
they
property, my
can't
lord.
keep the property. It's not an open house.
No, my lord, I'm
And
just
every weekend the property
for-
will be
for
open for
giving-
people to come and see.
for giving inspection, my lord, and
For
any,
giving inspection, madam, the property has to be opened up.
yes, my lord.
It can't be left open.
I'm not on that, my lord. If the if any term, if the corporation is asking for that, even bank can.
Yes.
My lord, entire outstanding without with entire dues without getting a purchaser, my lord, it's difficult.
That is
my
what
lord.
their terms are. They want the entire money.
Realizing ultimately from your ultimate cost.
My lord,
Pay off and take the who is talking. I'm not in the way. I want my money. That's all.
the entire outstanding
Of course.
means without. Other than kindly keep it after vacation. I will come back with the instructions because it's difficult.
5.
At the request of the parties, let this matter be listed.
Okay.
Lord, I am appearing for the Uttapara Court of.
Well, I am for the petition.
What happened?
A tax related matter, my lord. I am.
What happened? Criminal roster?
Yes, my lord.
Lord, on the other day, after.
Now you are doing tax matters also.
Yeah.
What happened to the criminal matters?
Criminal matter is going on, my lord.
Going on.
My lord, I am the owner of a, my lord. Yes.
On the other day, my lord, total tax due is 15,72,650.
Your lordship desire was, I directed him, what amount he will pay and what time. This is the total amount, 15 lakhs, probably largest junior appear.
Yes.
Yes. And my lord, the total amount my lord, due is 15,72,650. And out of that, what amount he will pay now? That was your lordship's question to the other side. And he took time for that.
But 15 lakhs is the total amount of the premises.
Total amount, yes.
And I am
Total
the,
amount for 10 years.
only kindly allow me to submit. And my lord, I am the owner of a, my lord, flat measuring about 1500 square feet, super built up area. And this is my first
1590 square feet.
1590 square feet, super built up area, my lord. I am the owner. So what they calculated, my lord, in respect of the entire building.
No.
I am saying, my lord. Number 2 point, my lord, they, my lord, described me as the occupier. And I time and again, my lord, requested them that I am the owner. Not
But we have no objection if he is a owner. If
Sir,
he is
can
recorded
we-
as owner, we have no objection.
Can we hear him?
So these 2 points. And my lord, I was very much ready to, my lord, give tax. My lord, they, my lord, declined to take, my lord. They asked me to pay the entire amounts. My lord, how? My lord, it is possible, my lord. The total entire amount calculation was made from their side.
But they are saying that it is only for your area 1590 square meters.
1590, my lord, my lord, so far my little knowledge goes, my lord, it is not possible 15 lakhs.
That's what they are saying. Are you calculating the amount for his portion or for the entire property?
Portion only. His portion only.
How is the calculation done?
Not other Jekku Sara, not Konika Singh, he has been separately assessed. And Sujita Acharya, he has been separately assessed.
See, what I can do is, it will be better, you have made a representation.
Yes.
Let them consider the representation.
And in the meantime, my lord, Lord, he
Yes,
is
that's
In
right.
the meantime, nothing, you
rent-
can,
getting rent not per month 45,906 per month from Lord Bank of India.
sir, you consider his representation.
Yes, we will consider. Lord, he must pay something, Lord, before Lord.
After considering, hearing will be made within
After
4 weeks.
consideration, whatever the amount is, you take it, consider his representation first. Take down, the petitioner has preferred the present writ petition. Seeking a direction on the respondent municipality to assess property tax on the proportionate share of the premises purchased by her by it conveys deed dated 11/12/2023, and to mutate the said property in her name, full stop. It is the case of the petitioner that she had purchased a commercial unit at measuring 1590 square feet, along with the proportionate share of the underlying land situated at holding number 66, PPMB Sarani, ward number 9, under the jurisdiction of Uttarpara Kotrung municipality. Full stop. Following the said purchase, the petitioner submitted an application dated 20th July 2015 before the respondent municipality seeking mutation of her name in respect of the purchased portion. Pursuant thereto, the West Bengal Valuation Board issued a notice under section 9(3) of the West Bengal Valuation Board Act 1978, proposing annual valuation of the premises. The petitioner filed objections to the said proposed valuation. Full stop. Upon considering the objection, the respondent municipality finalized the annual valuation and issued a property tax bill along with a surcharge for a net amount of 1,04,100 with quarterly installment of 26,025. The said bill was issued in the name of Srimati Kalyani Mondal and others as owners, and the petitioner, Srimati Dola Mishra, as occupier. Full stop. The petitioner submitted representation before the commissioner of the respondent municipality, pointing out that she is not only an occupier but also the lawful owner of the subject portion of the property conveyed to her by the aforesaid registered sale deed. Full stop. She requested that her ownership be duly reflected in the municipal records, and the property tax be levied accordingly. Full stop. However, no steps have been taken by the respondent municipality in this regard. Full stop. Subsequently, the petitioner has received another consolidated notice for property tax outstanding for a demand of property tax outstanding at rupees 8,54,821, wherein again her name has only been reflected as an occupier, thereby denying her the ability to discharge her tax liabilities in respect of her owned portion of the premises. Full stop. It is her specific grievance. It is the specific grievance of the petitioner that her name be mutated and that the property tax of her proportionate area should reflect her as the owner, and the demand be raised upon her. Full stop. She had further submitted a representation dated 20th January 2023. Full stop. However, no decision has been taken on the said representation. Full stop. Learned counsel for the respondent municipality submits that he is ready and willing to consider petitioner's representation dated 20th January 2023. Full stop. Learned counsel for the petitioner submits that he shall be satisfied if the same is considered within a time-bound manner. Full stop. In view of the statement made by the counsel for the parties, this court directs the respondent municipality to decide petitioner's representation dated 20th January 2023. Respond number 2. Who will decide the representation? Just ask.
My lord, that is my lord.
Your chairman will decide.
Yeah, no, Board of Council.
Board of Councillors. The respondent, I'll just keep respondents. Who will decide the representation?
Board of Council. Board of Council.
Respond number 3. Respond number 3 to decide petitioner's representation within a period of how much time?
Not 15 days from
In a period of week,
15 days not leave from
of puja, within a period of 8 weeks. Within a period of 8 weeks, strictly in accordance with law, after affording an opportunity of personal hearing to the petitioner, by way of a speaking order. Full stop. With the above direction, the present petition is disposed of. Affidavits have not been called for. None of the contents are reported.
Highly obliged, my lord. Highly obliged.
Yes.
'99 and Regulation. The regulation and bylaws. And A, 168A, small a.
Well, I appear for the private respondent.
This is my application, Malad.
In this matter, whether I will be praying for affidavit, yes or affidavit.
No, Malad. Kindly permit me to place the application, Malad. Petitioner agreed by a mutation done by the KMC, Malad, in respect of my father's property, Malad. Malad, all of a sudden, one fine morning, we find, Malad, that the mutation of my property has been changed. Entire thing has been changed, Malad. The name. So, Malad, we went to the Kolkata Municipal Corporation. They said the mutation has been done, Malad, in respect of third party, Malad. Although we have never transferred the property to anybody, Malad. Thereafter, we made a representation before the Kolkata Municipal Corporation. Is it tied over the matter, Malad?
Yes.
Thereafter, one reply came to file all the necessity documents relating to that particular property. We have filed. Thereafter, they sit tight over the matter. Thereafter, we filed one application under the RTI Act, Malad, for obtaining how the mutation has been done, Malad.
Yes.
That RTI, in reply to that, they didn't turn up. Thereafter, we went to appeal.
Yes.
Appellate court directed for giving the reply, the RTI, and then we got all the things, Malad. Malad, page 44, it starts, Malad, the mutation form, Malad. 45, 44, that is the requisites, Malad, we have given.
Which page?
Page 45, Malad. That is the mutation form which we have obtained through KMC, Malad, by which the mutation has been done, Malad. Page 46 is the relevant, Malad. 46, point number 5, Malad. Mutation due to transfer except under Cooperative Society Act and West Bengal Apartment Ownership Act, it has been given a tick mark, Malad. Thereafter, Malad, my lord, kindly sees page 50, Malad.
Yes.
Page 50, point number 5, at the bottom, Malad.
Page 50.
Down. Mutation due to transfer except Cooperative Society Registration Act and West Bengal Apartment Ownership Act, Malad, which is required. Next page, page 51. Attested copy of the registered deed of conveyance showing devolution of recorded owner to the applicant, Malad. That is not appended with that application, Malad. My lord, kindly sees what has been appended. One gift deed, which is appended at page 58, Malad. That is the inter wife was transferred. The father has transferred some property in respect of son. And from that particular deed, what we find page 62, Malad.
It's a registered gift deed?
Yes, registered deed.
Yes.
It's a gift deed. Inter wife was transferred. Not, Malad, deed of sale or anything else, Malad, from the recorded owner. It's showing from, just a gift deed. Malad, in that particular gift deed, page 62, my lord, kindly comes. There, my lord, it has been stated, my lord, second paragraph, my lord, and whereas the deed of conveyance dated 20th June 1969 between Kali Shankar Das, this is my father, my lord, Kali Shankar Das, and Abdul Islam, recorded in book number 2, volume number 15, page number such and such. Abdul Islam here a donor become the owner of the scheduled property and also Abdul Islam's name was never recorded in that particular property. And my lord, regarding this, my lord, we have a very suspicious. Therefore, my lord, we went to search out that particular deed. We didn't find anything. Thereafter, my lord, we made a RTI before the registering authority. My lord, kindly comes. My lord, kindly comes to my lord, page 104, my lord. My lord, regarding in that part, point number C, my lord, kindly inform me regarding that deed, my lord. We have sought for the from the registering authority. My lord, there, my lord, thereafter the reply comes from the register of assurance, my lord, at page 105, my lord.
All RTI based cases.
My lord, it's particularly says, my lord, that book number 2, reason under the registering authority, my lord, is a reason for refusal of registrations, my lord. At the bottom, my lord. As per your request, the mentioned volume is available in the central record section of this office, but other details did not match with the record available in this office. I also need to inform you that as per section 51 of the Registration Act 1908, deed of conveyance is recorded under book number 1, and book number 2 keeps record of reason for refusal of register. So, my lord, there is no registration document, my lord. Here, my lord, I am relying on section section 183.
So what did you do after this? Did you file any petition? Did you lodge any complaint? What have
Yes,
you
before the KMC authority, my lord, we made 2 representation. They didn't turn up, my lord.
I'm saying after this,
my lord,
what have you done? What are your civil remedies? Did you do anything? Did
For
you ask for
cancellation-
cancellation of the deed?
No deed is there.
Give deed is there?
If it is there.
No, my lord, give deed, my lord, it's a inter was transfer, my lord. It does not shows, my lord, devolution of interest, my lord.
All right.
My lord, I'm relying on 183, my lord, subclause 3 of the Kolkata Municipal Corporation Act. That I'm just handing. My lord, the act says, my lord, the notice of transfer, my lord, 183. My lord, I'm skipping the above provisions, my lord. I'm relying on 183 subclause 3. The notice under this section shall be in such form.
Yes.
The notice under this section shall be in such form as may be prescribed, and the transferee of the person on whom the title devolves shall, if so required, be bound to produce before the municipal commissioner any documents evidencing the transfer of devolution, my lord. My lord, the act says the devolution has to be shown, my lord. The form says, my lord, the devolution has to be shown, my lord. Nothing is there, my lord. Thereafter, my lord, the name has been incorporated, my lord.
So the gift deed is not devolution.
No, my lord. Devolution of title is not there, my lord. It's an inter vivos transfer, my lord. And page number 30, my lord, my name was recorded earlier that all the tax bill are there, my lord. And thereafter, my lord, even then, my lord, we made a representations before the KMC authority, my lord, which is annexed at, my lord, page 32, my lord, 32 to 37, my lord. They did not turn up, my lord. Thereafter, they says to file all the relevant documents. My title did everything we have given, my lord.
This is 2022. 22.
Yes, my lord. Thereafter, my lord, another representations, my lord. My last representation, page 106. Page.
Your representation I can understand, but why didn't you do anything? For last 3 years, you're sleeping.
My lord.
You're coming to this court in 2025.
My lord.
You're well aware of this, all this in 22. Last 3 years, what were you doing? Making representations.
Yes, 2023, my lord, representation has been.
I'm saying, sir, in 22, you were aware of the situation.
Yes, my lord.
You are coming to this court in 25.
Not my lord, 25, my lord. It was filed in 2023, my lord. It was called on several occasions. They did not appear, my lord. Even, my lord, before justice.
It was never called.
No, apni ছিলেন. The private respondent was not there. Before Justice Kaushik Chandra, my lord.
Never called.
Yes. Yes, what else? Anything else?
My lord, I am praying for cancellation of the mutation, my lord.
Yes,
So far as I am concerned,
you are the only
Yes.
one concerned.
there is a document, good, bad, indifferent, it has been registered. Now, my lord, I cannot, my lord, function as that.
You
of
just
the
overcome that page.
58 is the deed.
No, you just overcome this clause on page 51.
Page 51. Yes.
Attested copy of registered deeds of conveyance. So gift deed will be part of this.
My lord, to the understanding of the authorities, it would be because it has a touch, it is touching the title of a person. I have a title, I have gifted, my lord, it's just because he is the son.
Yes.
My lord, I could have gifted to any XYZ. The moment I give, and if it is a landed property, my lord, naturally I have to take into consideration that document which is there. And till that document is cancelled by a proper civil court, that stands in front of me. My
Correct.
lord, I cannot sit in appeal over that because
Correct.
I do not have that power.
Correct.
So this is the situation. I leave it to your lordship. Even the consideration of
Why
the
you have not
representation
asked for
cannot
cancellation of
be
the
there.
gift deed?
He has to ask for that. Before a
The
proper
inter
civil court.
was transfer,
Not
my lord.
inter vivos transfer, sir. It's a registered deed. It's a registered deed. As far as corporation is concerned, there is no illegality in the order
But-
passed by the corporation.
Corporation is the authority to look into that particular
Sorry,
deed,
sir,
my lord.
They have looked into it, and this actually, as far as the conveyance is concerned, the gift deed does put the property to the, you are the son,
I'm the private respondent.
private respondent.
My lord.
The property stands transferred by the way of the gift deed.
No, my lord, there is no, my lord, title, devolution of title, my lord.
Show me some judgments on that. I'm not convinced. Otherwise, I'll reject it. I'm not convinced. I don't see any illegality in the action of the corporation.
My lord,
As far
in
as
the-
their
in
due
the
diligence
gift
is
deed
concerned.
itself, my lord, what says,
See, they have acted upon the gift deed. If you would have challenged the gift deed in a civil proceeding or whichever proceeding you wanted to, then I could understand that the corporation has done something which is illegal. Today, I don't see any fault in corporation's action till the time you don't challenge the gift deed. Gift deed has conveyed the property. There's a conveyance of the property in favor of XYZ, whatsoever it is. You should have challenged the gift deed.
my lord, here, my lord, another part is there, my lord. After filing of this writ petition, they went to the civil court, my lord. They filed a civil suit, my lord. That was dismissed for default, my lord. I'm just handing over.
That is, I'm not concerned with that.
Yes, my lord, civil suit, my lord.
Sir, I'm asking you.
My lord.
Sir, I don't find any fault in action of the respondent corporation in mutating the property in the name of the private respondent in terms of the gift deed.
Lord, my respectful submission, corporation cannot do that, my lord. The corporation has no authority, my lord, since in their form itself, my lord, it is written, my lord, that devolution of interest has to be shown. My lord, from the gift deed itself, my lord, there it does not show, my lord, devolution of interest, my lord. My lord, kindly sees, my lord, their gift deed, what they have written, my lord.
All right.
My lord, kindly sees, my lord, page number 51, my lord.
Yes.
It has been written, my lord, is showing devolution from the recorded owner to the applicant, my lord.
Yes.
My lord, kindly come to page 30, my lord. I am the recorded owner. So, my lord, from my name to their name, my lord, transfer of this name, how that has been done by the KMC authority, my lord, without having anything, my lord. From Kali Shankar Das to Saidul Islam, my lord, there something has to be there, my lord. There must be any deed, my lord. No deed has been annexed.
That is a deed, sir. The gift deed is a deed.
Deed, my lord, kindly sees, my lord,
It's a
the gift deed,
registered
my
gift
lord,
deed.
which starts at page, my lord. Kindly sees, my lord, the gift deed, which, no. page 6, it start at page 58, my lord.
Yes,
Page 60, my lord, kindly come.
yes, sir.
It says, my lord, Abdul Islam is a donor and other part is Shohidul Islam. Other part, Doni, my lord. Therefore, no name of Kali Shankar Das is there, my lord, in the deed itself, my lord. Done.
Yes, Mr.
The gift deed.
Give it.
My lord, would kindly come to page 62,
Yes,
last paragraph. The
Yes.
donor, out of his natural love and affection for the donee, being the son of the donor, has voluntarily and out of his free will, has decided and agreed to make a gift of the scheduled property in the, is mentioned in the scheduled premises number 36, Fajlul of Sharoni. PS
oh, but
Paraya,
that, no, Mr. Mukherjee, please see page 60 first.
60. Yes, ma'am.
Who's the donor?
Donor is my lord Abdul Islam,
How can he be the donor?
and it has been given to Shahidul Islam.
Yes, how can he be a donor?
But again,
Because the
what has fallen from your lordship,
No, Mr.
if he cannot be prima facie, if he is not, and he cannot be say, my lord, can I go into that part? Only question is that.
The question is, then we have to look into this, because if he's not the donor, the donor has to be Kali Prasad
If he
or
does
whatever,
not-
Kali Prasad, right?
Kali
What-
Prasad Das.
Kali Shankar
Whatever,
Das.
Kali Shankar, Kali Shankar Das. That person could have been the donor, he can't be the donor. It has been very craftily, if you see that,
Drafted. Very craftily drafted.
absolutely.
But again, it is a registered document.
No, but you have to, it's a registered document, but the registration is between two people. Donor and donee are entirely
One
different.
should kindly come to page 62.
No, 62, yes. Inside they have played with it.
Now, what is there? And whereas by a deed of conveyance dated 26/69.
Mr.
Between
Mukherjee,
Kali Shankar Das
that
and
has
Abdul
that has to
Islam.
be seen then.
Your lordship has seen that?
I have seen that, but that deed has to be seen. See, this is all, there is more to it.
Well, as a person, he is only recording the name for the purpose of
No, this is,
collecting tax. Can he go into all this?
at least you can see who's the donor and the donee. That much you have to see. That much you have to see. For the property,
They have seen and they have found a registered document based.
Registered, registered in, this like my property, but you gifted to him, my property.
Exactly.
It's my property.
Exactly. That
I
is-
should be the donor.
After reading.
But Mr. Mukherjee is giving it to,
After reading, I found it to be like that.
that's exactly.
But still it is a document in the eye of
Alright.
law.
But we are not blind to it. The person who's doing it, then Mr. Mukherjee, there is malafide,
Of course,
there's dishonesty.
yes.
That action of a corporation can be looked into. That action of the corporation can be looked into by the court.
Your lordship can send it back to revisit the whole issue.
And lordship, in this matter, I need to file an affidavit because my lord.
What affidavit?
My lord,
No
because my
affidavit.
lord- Because
You have no right.
Because my lord, may I just submit?
No affidavit.
My lord,
You look into this.
my lord, they are,
You decide his representation in that case.
Then my lord would indicate because.
I will indicate.
Indicate two things.
Yes.
When I consider his representation, I can go into this aspect of the matter. Because otherwise.
At least-
Consideration becomes a fruitless exercise.
I'll do that.
And the question of title, my lord, possibly cannot be decided by the corporation, my lord, first of all, my lord, because, my lord, it has been sold to, my lord, the donor, my lord.
It's not
Yes.
sold. It has been
It is
given
not
out of
sold.
natural
No, no,
love.
it has been sold to the donor, my lord. Thereafter, donor gave it to the donee, my lord.
That document has never been with the corporation.
Let
You
us
know how we have played.
My lord, let us produce that document before the corporation.
You forget it. You go where you have to go.
Let us produce that document before the
You
corporation.
go wherever you have to go. Take down.
My lord, may I humbly, my lord,
Yes.
put me a question, my lord. There are after filing of this writ petition, they went before the civil court, my lord. Their suit has been dismissed for default. There was a counterclaim filed by us where my title has been declared, my lord. I am handing over, my lord, those two documents, my lord.
So you take all this then if your title has been declared. You go before the respondent corporation. They will look into it. This is what I was asking you.
No, my lord. After filing of this writ petitions, my lord, they went before the trial court, my lord.
We can all smell it. We know what has happened. Take down. The petitioner in the presented petition, seeks a direction upon the respondents to delete / cancel the name of Shahidul Islam and restore the name of Kali Shankar Das as the owner in respect of premises number 30/6, Fazul Haq Sarani, Calcutta, as recorded in the records of Calcutta Municipal Corporation. The petitioner's case is that their deceased father, late Kali Shankar Das, purchased the aforesaid property by virtue of a deed of conveyance dated 24/12/1963. Full stop. The said property was duly mutated in the name of late Kali Prasad Das under assessee number 110619000310. Full stop. From the year 1965 until 2020, the municipal records reflected his name as the owner, as the owner of the property. Full stop. Following the death of late Kali Prasad Das, the petitioner, being his legal heir, claims to have succeeded in the said property. Full stop. On 8/4/2022, while approaching the respondent corporation to collect the property tax bill for the year 2023, the petitioner discovered that the assessee name in the record is that of one Mr. Shahidul Islam. The petitioner states that he filed right to information filed an application under the Right to Information Act 2005 and obtained various documents, including a certified copy of the gift deed dated 24th July 2020. Full stop. According to the petitioner, there are material discrepancies in the gift deed and hence the respondent ought not to have acted upon it for the purpose of mutating the name of Mr. Saidul Islam in the municipal records. Full stop. He further points out that in the gift deed, the name of the donor is one Mr. Abdul Islam and the donee is Shahidul Islam. Full stop. He states that his late father's name has been surreptitiously mentioned in the gift deed as if he's been transferring the property See, Mr. Mukherjee, how interesting it is. Page 62.
Yes.
The property is sold entirely to Kali Shankar Das, but suddenly in para 2,
Yes.
the deed of conveyance dated 26/1969, Kali Shankar Das and Abdul Islam.
Yes.
The name comes in here.
Yes. Who is the donor?
Who's the donor?
Who is the donor?
Just imagine, he becomes the donor and even the owner also.
Kali Shankar sold it to Abdul Islam. Now
How-
Abdul Islam is a donor.
Look at the way it is worded, Mr. Mukherjee.
Abdul Islam, herein donor became the owner of the scheduled property. Also mutated his name before the Kolkata Municipal Corporation. This is a question mark.
It was never mutated.
This is the question mark.
क्या लिखवाया है देखो.
This is how these are drafted.
He has transferred the property to one Mr. Abdul Islam, comma, the proclaimed donor in the gift deed. Full stop. Learned counsel for the petitioner further states that he had not been issued any notice before before his name was deleted from the record of the corporation and from the record of the corporation. Full stop. And deleted from the assessment record and that of Mr. Shahidul. क्या नाम है? Shahidul Islam was added. Full stop. He further states that he has made several representations before the respondent corporation, but the same have not been acted upon. Full stop. Full stop. His last representation is dated. What is the date?
Not date 30th December 2022. Page 106.
30th December 2022. Full stop. Learned counsel for the respondent municipality states that he is ready and willing to consider petitioner's representation dated so and so. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is considered within a time-bound manner. Full stop. After hearing after hearing the counsel for the parties, this court directs the respondent. Which respondent will decide, Mr. Mukherjee?
Chief Manager Revenue.
Respond number?
7.
Respond number 7 to decide petitioner's representation dated so and so. In terms of the fact that this court has observed that the mutation which has been granted in favor of the private respondent is based on a gift deed which actually records the donor and donee to be Abdul Islam and Shahidul Islam, and it has, and nowhere it shows that the property has devolved on the private respondent by a gift deed issued by him. by late so and so, by a gift deed issued by late.
My lord, not gift deed, my lord, sale deed,
Stop.
my lord. It has. my
Learned
lord-
counsel for the private respondent states that the property has devolved upon him by way of a sale deed which was executed by the late father of the petitioner, Mr. Late Kali Shankar Das, by way of a registered conveyance deed dated 26/1969 issued in favor of Abdul Islam, who is the donor in the present gift deed, full stop. The respondent corporation shall verify the respondent corporation. It is stated by the learned counsel for the petitioner that the respondent corporation shall, at the time of deciding the representation, shall ensure that the private respondent files the conveyance deed, which conveyance deed dated 26/1969, wherein the property has been transferred from late Shri Kali Shankar Das to Abdul Islam, full stop. From the record, it appears that this is the only document on which you have done it, right? From the record and the statement made by the counsel for the respondent corporation, it appears that they have acted only on the gift deed which has been supplied to them, and on the basis
And
of
the
the
mutation application.
and gift deed and the mutation application which had been put before them, which has led to the change in the record of the assessment record of the corporation, full stop. Learned counsel for the petitioner has also petitioner is also the क्या लिखा और क्या लिखवाया था keep in mind, क्या एक बार वो पैराग्राफ पढ़ना लास्ट वाला पहले this court has heard the submission of the learned counsel petitioner and respondent and directs the respondent number
in terms of the fact that this court has observed that the mutation which has been granted in favor of the private respondent is based on the deed which actually records the donor and donee to Islam and Saudi Islam. And nowhere it shows that the property has devolved from the private respondent by a gift deed issued by late Kali Shankar. Learned counsel for the private respondent states that property has devolved by way of the sale deed which was executed by the late Kali Shankar Das by way of registered conveyance deed dated 26/6/1969 in favor of the Abdul Islam, who is the donor in the present gift deed. The respondent corporation shall, at the time of deciding the representation, shall ensure that the private respondent
produces
the conveyance deed dated 26/6/1969, wherein the property has been transferred from Sri late Kali Shankar Das to
Abdul Islam.
from the record.
Keeping these observations in mind, the respondent corporation shall decide petitioner's representation strictly in accordance with law after affording an opportunity of personal hearing to the petitioner as well as the private respondent by way of a speaking order. With the above direction, the present writ petition is disposed of. Mr. Mukherjee, will this be enough or?
Your lordship only takes note of the instruction given to me, paragraph 3. Because what I was submitting, that is, your lordship would see paragraph 3. The mutation was approved.
Mr. Mukherjee, I was with you.
No,
I was totally with you till the time I saw that the gift deed itself.
The language of the gift deed. But the question is still today, my lord, at the deepest of him, my lord.
They should have seen, Mr.
But they
Mukherjee,
cannot-
if,
they
no, they
cannot
could have.
sit in appeal over that gift deed.
The gift deed doesn't transfer it.
How can I say that, my lord?
The
That's
gift,
the
no,
question.
Mr.
How can I say-
Mr. Mukherjee, the gift deed is between two individuals,
Yes.
Abdul Islam and Muhammad this Shardul. And nowhere the petitioner's late fathers,
Is there
they should have at least asked.
in that part, that whether who was the taxpayer, and from that taxpayer,
The conveyance deed,
It has
at
to
least
be there.
gift deed today, even if I buy your argument to that extent, they should have not acted on the gift deed.
that ought to have.
They should have not acted.
Kept the mutation application pending.
Pending.
That's all. Let him come.
They should have issued a IN to them, asked for more documents, and then they should have acted upon
Yes.
it.
Blindly followed that because it was a, your lordship says that because it was a registered deed, we have. That's the.
Registered, if it was,
Lord,
see, I would,
Your
honestly, if,
lordship is not aware of, in Bengali, we say, Machi Mara Karani. The clerks, whoever, when they see a dead fly, they will try to copy that dead fly and the file. So it's like that. They do not lift the document and see what it is for.
no, but,
And whether
but there can be,
actually it can be acted upon.
but Mr. Mukherjee, there can be more to it. There can be much more to it.
Yes.
This is transferring literally your,
And that also they have seen the person who is the father is giving. To whom it is being given? His son. So prima facie they are satisfied with that part.
correct.
Then, Malad,
And look at this,
and that articulate
sale deed of 1969.
that articulate drafting, you have to understand what the actually meaning of those clauses, recital and haven't done.
Very
So
smartly.
who is going to put that head into it?
And what is it? They are saying that they have given the property jointly to Kali Shankar Das as well as Abdul. Jointly could have never,
No, my lord, my lord, not that.
There's something else.
Not joint, not
way,
joint.
the way they have drafted it, it will.
It's
Not
a
jointly.
drafting.
Let the time frame, my lord.
Representation
ভাই সামনের মাসের মধ্যে
within
হবে
12
না, এটুকু তোমায় বলে দিলাম।
within
এবার তুমি যত
12
time
weeks?
করো।
You want, Mr.
Balo 10 weeks.
10 weeks?
Yes.
12 weeks I was giving.
Yes, your lordship gives it 10 weeks or 12 weeks.
10 weeks.
Because corporation is on holiday for 28 days.
I know.
It would be a day before from our holiday. It will start.
12 weeks?
12 weeks. Mandatory, my lord, 12 weeks, my lord. That will suffice, my lord. And my lord, somewhere it has been probably at the time of dictator of Kali Prasad Das. My lord, it ought to have been Kali Shankar Das, my lord.
Kali Shankar.
Lord, kindly keep the instruction on record.
I'll keep the,
Because nobody says that I have submitted something which was not instructed.
should I record your submission also?
No, your lordship doesn't have to, but only the instruction forwarded to the honorable court is kept on record.
The instruction forwarded to the counsel for the respondent corporation is kept on record.
Grateful, mother. Much obliged.
Lordship, I am for. Lordship, I have consulted with my client. He has said that he has filed the earlier writ petition, but before that, kindly come on the page number 40.
Madam, if he has filed another writ petition with the same self cause of action, this is not maintainable, right? Then I'll impose cost and I'll dismiss this.
Kindly, bear here for a moment.
Two writ petitions can't be there, madam, please.
Lordship, the earlier writ petition was for dismissed for the default, so it was
So
not.
that has to be restored. If it is dismissed for default, that has to be restored. All right, you move an application for restoration. This writ petition will not survive.
Lordship,
If it is dismissed for default, doesn't entitle you to file another writ petition barred by res judicata.
no, Lordship, then I want to place a judgment. There is a division bench judgment, Lordship. If any writ petition has not been decided on its merit, then it is not falling under the.
I am aware of that. You move an application for restoration. I am not entertaining this.
Not to place this writ petition, Lordship.
Learned counsel for the petitioner does not wish to press the present writ petition. The same is dismissed as withdrawn with liberty to the petitioner to take appropriate proceedings in accordance with law. Great one. Move a restoration, I'll allow it.
Great.
May I please, Your Lordship? A petitioner before Lordship is engaged in a civil.
Learned friend starts. Before my learned friend starts, I have a 2 point of demur. Should I take that? Your Lordship, first point of demur is, if your Lordship kindly turns to prayer of the writ petition.
Oh, that is in the.
No, that's all right.
No,
This is my
in a
point
merit
of demur.
person.
I can take.
No, no, you can take the preliminary point. So, but the demurrer point is concerned, you are going to the prayer portion of the writ petition. So in the.
I think.
Yes, what is it?
My lord, it's a money claim in a writ petition. Kindly see exact that money to give. First. Second point of demurrer, this money is coming out of a commercial contract. Enforceability of a commercial.
I generally interfere only if it's an admitted amount. Is it admitted?
Yes, admitted. Admitted amount.
If it is admitted, then I.
What's the admission?
And everything is there, my lord.
Show it. That's what he's saying. Show it.
My
If
lord,
it is admitted amount, because I am also very reluctant to enter into this civil dispute, private disputes between the.
It's not my lordship, it's a contractual.
No dispute.
Enforcement of a
I don't.
private.
I have a very clear concept in this, Mr. Lahiri.
All right.
I
Then,
only.
Lordship, I will try.
No, I'll tell you. No, you're right. I appreciate what you're saying. I'm with you on this. That I don't want to get into contractual contacts unless and until it is an admitted amount.
First thing. And second thing is, if the contract is a.
And that too, my view has changed only after coming here, by the way. Because there are too many judgments of this honorable court, wherein if it's an admitted amount, there are directions which have been passed.
May I say? Lordship, question of admitted, non-admitted amount will take care of that disputed, undisputed fact.
No,
But
Mr.
when it is,
We will not get into that aspect.
Lordship, if I divide the issue into three, one is disputed fact, one is money claim, and one is enforcement of a commercial contract.
We will not get into that. That's too big an argument to handle. Let us see if it's admitted amount.
may I please, Your Lordship?
Yes.
Page 33, the tender, each tender was, my lord, invited on
Page 33.
page 33.
Yes.
This is the each tender was invited, and my lord, I took part, and ultimately, my lord, the work order was issued. Page 33 and 34. This is, my lord, the tender paper, and thereafter, my lord, page 35. This is the work order issued in the name of the petitioner.
Admission.
You got it.
Yes.
My lord, so after work order was issued, my lord, I completed the entire work,
Yes.
and my lord, I raised my bill at page 36 onwards.
Yes.
And my lord, ultimately, my lord, thereafter another tender was floated, and there also I took part in respect of separate work. Here also, my lord, I was issued work order. My lord, tender paper is, my lord, page 42, second one.
So these are work orders which have been issued to you.
My lord, in respect of first work order also, I have done there are two works,
Yes.
two different works. In respect of first work, that is, my lord, in respect of the tender dated 5th May 2017.
And my lord, in pursuant to
Page 36 is this 2517.
My lord.
The next one is also 17,
My lord.
2517.
Yes, my lord. Yes. Next one is my lord, 16 October, November 2017. Next work order.
I have not
That is
taken
all.
that point because
I know what you're saying, Mr. Lai.
because
That has already crossed my mind. I know what you're saying.
last page, Lordship, 22,
That is my lord.
October 22. So I have not taken that point.
Page.
Know what point you're saying. Yes.
Page 42, my lord, second tender as was my lord floated. That is my lord, page 42. And my lord, pursuant to that tender, my lord, I was also issued the work order. Page 48. Second one.
All right. Yes.
And so far the first tender is concerned, my lord, I raised a bill. That is, my lord, at page 36. First tender is concerned, my lord. I raised bill, page 36, 37, 38, 39, 40, and 41. Total amount is, my lord, 43 and odd. Total amount. $43,17,707. And my lord, thereafter, my lord, another tender was floated. That is, my lord, page 42, dated 16th November 2017. And pursuant to that, my lord, the work order was also issued, page 48.
Yes.
My lord. And thereafter, my lord, I also raised bill, page 49. My lord, the bill I raised, only one page. And all the bills, my lord, below. My lord, I'm just only at page 49. If you kindly have a look to the page 49. At the bottom, my lord.
Yes.
Certified that the necessary details measurement have been taken by me on 11 June 2017 and recorded at page such and such, signature of the sub-assistant engineer, overseer, officer in charge of the work. And certified that I have examined the work and I have satisfied myself to be the best of my ability that has been carried out in accordance with the sanction plan and estimates. So after, when I raised the bill, this is the recommendation by the overseer and thereafter engineer. And thereafter, I raised, even after raising bill, when I did not get any reply or no amount was released, then I started to write letter, page 50, that is so but my honest money, even my honest money is also withheld. The next page, page 50, I first prayed for refund of my honest money. That is also not given. Page 50. This is my with respect of my honest money. I prayed for refund my honest money. Then I wrote another letter, page 51. That is this is at the bottom, fourth reminder, dated 20th March 2020. Page 51. Here also I made request to pay the entire amount that is in respect of my first work is concerned. That is 43 lakhs and odd. And thereafter I wrote later and ultimately the chairman itself, himself also last letter, in respect of my tender, first tender is concerned, page 65. I wrote a letter to the chairman. Here I prayed for making payment amounting to 43 lakhs, 15,000 and odd. And my lord, apart from that, if you will kindly come to page 68 and 69.
Yes.
This is the certificate issued by the chairman Bhatpara municipality. Here it is clearly stated, may I be permitted to read it. This is to certify that Messrs. Bicon, 29K Garden Graham Road, 77/1, Santigor, Kolkata, 40. A bona fide contractor was asked to execute the following work of development of the local area. The said
contractor completed the work in all respect as per specifications laid down in the schedule satisfactorily. No complaint from the concerned area has been received in the municipality against his workmanship. And there are total amount at the bottom right hand side 43 lakhs and odd. So this is the in respect of first work, this is the certificate. And next one is page 69. Here also the chairman issued certificate. This is to certify that Mrs. Vaikon such and such is the bona fide contractor of Bhatpara municipality has completed the work for proposed concrete road at different places of Monasha Colony, Narayanpur, Nareli Road, Dashpara and Badamtola in ward number 33 and 34 under Bhatpara municipality in all respects as per the specification laid down in the schedule satisfactorily. The following information is being furnished in connection with the above work. Name of the work, the proposed concrete road. The next one is name of the contractor, Messrs. Vaikon, the petitioner hearing, and work order dated the right hand side, 29 December 2017, and the estimated amount 36,000 such and such, tender amount 36 lakhs such and such.
All right.
So this is after completion of work, I raised bill. This is my
Yes, Mr.
fault. That
Lordship, my learned friend took over the.
Now you can make all your arguments.
Yes. Lordship, there is no admission. It's all commercial document, raising bill, giving work order. There is no unambiguous admission. First. So it is a money claim. Second, it is an enforcement of a commercial document. So regard to the first claim is concerned, first NIT is concerned, Lordship, there is no document after 2017.
Yes.
So far as the second document is concerned, the date of signing is October 2022.
Yes.
In a writ code, we cannot split the amount which he has paid. This much is time barred, this much is not. I did not take the question of time barred because it is a mixed question of law and fact, and it was there in Lordship's mind, so I took it from the Lordship's brief. I took that point from the Lordship's brief, to be candid. So to develop that point, Lordship, one part is completely time barred and one part is not time. Now, there is no procedure in the writ court to make this difference. Prayer is absolutely money claim. Now, Lordship will first entertain this or not, then I will come with the disputed fact that what he constructed is right.
Take down the petition, the present writ petition is challenging the inaction of the respondent in not releasing the outstanding amount due towards the completion of work contracts awarded to the petitioner. Full stop. It is the case of the petitioner that the respondent municipality awarded work order dated 12/6/2017.
If your Lordship needs a latest judgment on these 2 points, Lordship, I am ready.
I'll just take a bit. First work order is page 33, sir, right?
page 35, first work order, page 35. 12/6/2017.
12/6/2017 and 29/12/2017. Full stop. For the construction of full stop, comma, for the construction of various roads under the Bhatpara municipality. Full stop. The petitioner states that he successfully completed the said work and was issued
Bill raised page 36 onward.
issued certificates from the municipality. Full stop. He had raised several bills for the said amount. Full stop. He had raised several bills for the said amount, however, the amount was not released to him. Full stop. He states that he had made various representation, but the same have not been acted upon. Full stop. Learned counsel for the respondent municipality submits that the contract was issued way back in 2017 and 2022, The petitioner
No.
chose
Both are 70.
way back in 2017, and the petitioner chose not to file any appropriate proceedings, full stop. He states that the present dispute arises out of a contractual
Commercial.
contract, full stop. He further states that it is a money claim and the writ court has no jurisdiction to look into the said disputes, full stop. He further relies on the judgments.
Or should I have the noting? Should I give all?
He give the just two judgments, sir, whatever the
বলে দিন না, মুখে বলে দিন।
Just, open.
judgments. He further relies on the judgment of the Honorable Supreme Court in 2015, 7 SCC 728 and 2008 SC 2585 to impress upon the said contention, full stop. This court has heard the argument advanced by the counsel for the parties and has perused the materials on record. It is evident from the record that the tender which was issued in favor of the petitioner was of the year 2017. The petitioner had entered into a contract with the respondent municipality for construction of roads, full stop. The petitioner has been raising bills time to time, but he states that no payments have been received, full stop. The issue is purely contractual in nature, and the writ petition is more of a money claim with disputed question of fact, full stop. Nowhere from the record it is evident that the respondents have admitted to the petitioner's claim, full stop. The petitioner has only been able to show certificates issued by the municipality wherein the municipality has appreciated the fact that the work has been completed, full stop. The present writ petition, the present writ petition is not maintainable in view of the judgments laid by the Honorable Supreme Court, in view of the above mentioned judgments laid by the Honorable Supreme Court, wherein it is clearly pointed out that in contractual matters, the writ court shall not exercise its discretionary jurisdiction. In said fact, the present writ petition is dismissed.
I'm deeply opposed. I was told in the ND meeting last time, few lawyers of your parent High Court was really saying that we are missing Malad. Today, I really sympathetic, including the past PP, public prosecutor. Richa was there for a long time. Richa Kapoor and.
Right. They have all been my colleagues.
Only thing, my lord, I may be permitted to submit.
Yes.
This is an admitted amount because at the bottom of the bill, the authority concerned are certified.
Sir, you should have filed a recovery suit.
And so apart from the certificate, that bill is endorsed by the officer concerned.
File a recovery suit, sir. File a writ petition for these things. I shouldn't say it, but in this court, I have seen a lot of orders like this, but generally the law is very clear. Writ court should not interfere in contractual matters at all. Very clear law. We have been very benevolent in putting it before the corporation to consider representations, but it's only when it's admitted.
The difficulty is lordship knows that if suit for recovery of money, it will take how long? Nobody knows. Even after
doesn't take much time.
That is how the law is.
So,
you have been sleeping over your right from 2017 onwards.
Yes.
This is a limitation. I'm not pointing it out. This is completely barred by limitation. Barred by limitation too.
yes, that is also another problem.
That is the problem. That's why you have filed this writ petition, sir.
No, Malla,
It is filed only to overcome that difficulty of yours. Otherwise, you also know where to go.
it was filed
It is filed only for this purpose.
No, they try to pursue the matter so that they can get, they try to write a letter.
Writ is filed only for this purpose, to overcome this difficulty of limitation. Otherwise, you also know where to go. Everybody knows where to go. Every lawyer sitting here knows where to
Yes.
go. The writ is filed only for this, to overcome this difficulty.
Not only, not always, my lord. Anyway, my lord, as well as.
Rest of the matters tomorrow.
May I have your lordship's kind leave, my lord? This is a matter which was mentioned before your lordships today morning. Your lordship granted leave, my lord. I'm only seeking for a direction that, my lord,
Leave?
leave was granted by your lordship, my lord. I'm only
Granted for what? For
for
listening?
a urgent hearing on the 24th, my lord. That is there. We have filed the matter.
Good.
Only, my lord, I seek your lordship's kind leave to pass a direction upon Mr. Shonak Bhattacharya. He generally appears for the Asansol Municipal Corporation. So, my lord, if I
Serve upon him, he'll take it. If he
no, my lord,
refuses,
he's if
sir,
if he,
you serve it, get a refusal from him, then I'll take care of it.
much obliged. Much obliged.
May I mention a matter regarding item number 47, my lord? I'm coming.
47 is too far.
Only one prayer maker.
Yes.
Liberty may be given to the appropriate.
Liberty. Dismiss करके उसमें वो line निकाल. With liberty to the petitioner to approach appropriate forum in accordance with law. Rest of the matters tomorrow, madam.
Item number, can it be the same situation?
We'll see tomorrow. See.